Mention item 15 for respondent number 2. May this case may be fixed after vacation, Your Lordship. I have taken the consent of other side.
You are for the respondent.
Respondent 2, private respondent.
Taken consent of the other side.
I have taken the consent from the petitioner. 15.
Taken consent of the petition and with the consent of the other side. You did finite it. Estimate accordingly after due vacation.
My lord,
You want to fix it after vacation.
after vacation.
21 for
And last week,
last week. 29.
highly obliged.
My lord, I want to withdraw my criminal revision petition because husband and wife settled outside the court.
Which one?
They're not listed, but on
Oh, make a mention before either before registry or before court number 8. It will listed before this court only. We are not allowing any mention.
withdrawal, my only withdrawal.
Withdrawal also, you can make a mention before court registry also. It can be listed here. Maybe tomorrow also.
My please, Lordship, I beg to mention item number 17. I have filed an additional affidavit, Lordship, that may be called
17.
17.
Yes.
May I please, Your Lordship. Well, at item 7, I have a small correction, well, with typical mistake. I may be allowed to correct.
Huh?
Item number 7,
Ah.
only small correction, well, typical mistake.
No. We're not allowed. By hand, it's not allowed now. Not possible.
In place of 5, it will be 6 only, not other.
What to do? No hand correction.
May I please, Your Lordship.
No hand correction.
So regarding item number 23, perhaps case diary is not available. My lord.
Item number?
23, my lord.
23, my lord, in this case,
Yes, sir.
the search sheet submitted, my lord.
There's an interim, my lord, then that can be extended.
Charcy, yes, can you tell us the CS number?
CS number, my lord, 20/25. Sorry, my lord, 195/25, my lord. 195/25, dated 39/25.
39/20
5, my lord.
25.
Yes, ma'am. So,
Wow. That-
Interim was granted in August.
my lord, search sheeted against accused Bilaluddin, my lord.
Bilaluddin.
Petitioner number 1.
There are two petitioners, my lord. Hibzur Rahman. Regarding Hibzur Rahman, my lord, nothing has been only accused against Bilaluddin, search sheet submitted.
Against Bilal.
Bilaluddin on 39/25. But regarding other petitioner, my lord, nothing has
He
been.
was Hibzur.
Hibzur.
That prayer has already been made, I think. We are not just, will make a mention here. Otherwise, prayer for discharge has already been made by the IO, I think.
Yes.
There-
yes.
there-
In the trial court.
I heard Mr. S. Nawaz, the learned counsel for the petition, also heard Mr. P. Waterford. The learned additional PP, everyone said respondent. It is submitted by Mr. Waterford that case has already been charged by CS number so and so, it is so and so. Against one of the petitioners, that is Bilaluddin. Bilaluddin. In view of this, in view of this, the petitioner is hereby directed to approach the learned trial court with an appropriate application for bail, regular bail, which may be considered in accordance. However, till 15 days from the date of order, the interim order will either granted to the petitioner will be extended.
Well, deep look.
Wait, please, Your Lordship. I beg to mention item number 16 and 21, Lordship. Kindly pass over the matter for the day, Lordship.
Come on, item number
16 and 21.
16 and 21.
16, my lord, admission. 21, my lord, bail hearing, CD received. My lord, this matter pending from 2024.
Oh,
CD is here, my lord. I want to dispose of this matter, my lord. Item number 21, my lord, unnecessarily pending, my lord, here since long. My lord.
what is your difficulty?
Pass over
Item
the-
number 21, 16 is okay, we'll manage something, but
Ma'am,
21,
hearing is not completed.
Huh?
Not completed, Lordship.
not completed. Who is not completed?
Preparation is going.
Preparation is still going on.
Yes, Lordship.
What
So
is the
kindly
what-
pass over the matter for the day.
My lord, item number 21 is, my lord, regarding, my lord, he said 240 bags of, my lord, rice, my lord. Regarding the petitioner, my lord, already petitioner is in. And the vehicle, he is the owner of the vehicle. The vehicle is already handed over to him long back, my lord. So, my lord, unnecessarily matter is, my
What
lord,
needs for
here, so I want to
preparation?
dispose it
There is no
of, my
much
lord.
preparation is required. I think.
Yes, man.
Tomorrow, go with you.
Yes.
Let it be on tomorrow. Okay, it will be fixed on tomorrow. You make your preparation complete by tomorrow.
Hmm.
Please tomorrow, go with you. Better request.
Item number 21.
17th. List on 17th. 17.3, CDBDT. Yes, 16, have you taken consent of the other? Okay, state is there. no? What is the position of 16? We scan
16, my lord, TCR receipt. Scan copy of TCR receipt.
the consent of the other side. Is the state respondent? Wait for an adjournment. Where estimate accordingly. Pure. Hey, no. 23rd of April. 16. Was there any interim protocol? In 2016?
16, my lord, I have no idea man, regarding.
21 or interim be continued for everybody. Okay,
Must.
May I build up? The victim mentioned for listing criminal division, my lord.
listing.
Criminal
We
division.
mentioned before court number 8.
May it please your lordship, I beg to mention one criminal petition for listing for orders, lordship.
Make a mention before court number 8.
Lordship, this matter was last
Court
listed
number
on the-
8, make a mention before court
Bless
number
Lord.
8 or either before the registry.
Obviously.
It will be listed.
Lordship, I beg to mention item number 30.
1330.
30. Lordship. TCR has been received in this matter, but we have some difficulty today. Can it be listed next week?
It's a AB is, it's a charge sheeted case, I think. na?
Yes,
Yes, yes.
charge sheet receipt.
Is there any interim is operating? No.
No, ma'am.
With consent of the other side, you'll need counsel for the petition. Wait for an adjournment. Citing some inconvenience on their part. List the matter accordingly. When do you want?
Anytime next week, Your Lordship, 24th.
25th of this.
I'm deeply obliged.
May I please your lordship?
Yes.
Well, the petitioner was arrested on 27 of February.
Hmm.
And he's in jail since 18 days, he's in jail, my lord.
It's
So
a
I
case
have-
of 118.
Yes, my lord, 1-8.
No, 118.
Yes, ma'am.
Okay. Call for the case there along with the medical report, injury report. Yes,
Short date
what
may
are
be
you
given.
wearing?
In fact, my lord,
My lord.
no injury sustained, my lord, as per my instruction, my lord. So short
We
date
don't
may be
know.
given, my lord. This section is not present as per my instruction.
25th or 6th.
20
And item 7 also, my lord, from the same FIR.
25. Item 7.
Item 7, my lord, is the
It's a
anticipatory, my
EB.
lord. Here, two ladies is here, my lord. Kindly turn to the item 7.
Item
Number
7
7 to
also
the-
25-3.
And here two ladies, my lord. So I am praying for interim with these two ladies, my lord.
No issue. Interim will be, they won't be arrested. 1 and 7. CTP call for. Yes,
May I
2.
plead, Lordship? Lordship, in this case, altogether 7 accused were arrested, Lordship. And out of them, 3 has been already enlarged on bail, Lordship, on 13. Lordship, after perusing the CD, Lordship.
Okay.
So, may I please?
This 109 is also there, 118, 1 is also.
Yes, Lordship. But in the CD, Lordship, it is seen that actually no such incident took place, only simple injury caused due to scuffle with among some people.
Your petitioner is in custody since when?
27, Lordship, 27 2.
27/2.
Yes, Lordship.
What about 109?
109, Lordship, actually, that type of incident did not took place, Lordship, as per CD Lordship speaks. But the order reflects, Lordship, in para number 7 of the bail application number 635, Lordship, may be very.
635.
Para number 7, Lordship.
Ah.
May I read it, Lordship?
Hmm.
The additional public prosecutor submits that no firearm as such was recovered and alleged weapons of assault was some kind of a cigarette lighter shaped like a pistol. The medical report is available, which indicates injury in the nature of laceration. Very simple injury was Lordship. Actually, I am driver of one of the accused, Lordship, who has got already bail, Lordship.
Your petitioner, what is your case?
My case is the Lordship. Actually, on that day, when the incident took place, I rushed to the place of incident with my master, Lordship. I am a driver. And I was present, and at that is instead of time, Lordship, the police arrived, and all the people who were present in the spot, Lordship, were arrested. And no way I am involved in this case, Lordship.
With master means car. You are
Yes,
driving
I am
the
car driver, Lordship. Car
But
driver,
what
one,
is the allegation in the FIR as per?
yes, Lordship. It is in page number 16, Lordship. On man, may I read it, Lordship?
In front of the and the event. Yeah, but it's not going to be about save it. Yeah. We were like, কি হয়ে যায় না আর মুড মন যাব পারে না তো করে দিতে জানি এটা ভিউ লইতে দিছে ভালো আচ্ছা yes what is this?
Page number 16, Lordship. সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই জনাব বিচাৰিছো মোৰ নাম বিকি বসুমতাৰী, মই গুৱাহাটীৰ জাপৰিগড় নিবাসী। যোৱা ৰাতি ইংৰাজী 26/2/2026 তাৰিখে ৰাতি প্ৰায় 11 বজাত মই গণেশগুৰিত ভাত খাবলৈ আহিছিলো মোৰ লগৰ এজনৰ লগত। খাই থকা অৱস্থাত কোনো অচিনাকি লোকে আহি মোক কিবা পিষ্টলৰ নিচিনা সামগ্ৰীৰে মূৰত আঘাত কৰে আৰু মোৰ গলৰ পৰা সোণৰ চেইন ওলাই লৈ যায় আৰু মোৰ মূৰৰ পৰা প্ৰায় বহুখিনি তেজ ওলায়। এয়ে মহোদয়ৰ ওচৰত ঘটনা।
Yes, what?
Otherwise, yes, incident happened. It is not that no incident happened, but that firearm was not recovered, and that is not a pistol. From the paragraph 7, it was like a lighter, like material. But assault was the accused persons are involved in assaulting the victim. It is. And from the ground number 6 of the forwarding report reflects that at that point of time, probably they displayed some firearm, but after he went try, they probably thereafter concealed that weapon. That is
As a whole, how many was arrested? One.
Altogether
Seven.
7 person.
Yes, Lord. All people who were present at that time, Lordship. Police arrived at the place, Lordship, patrolling party. And I am not involved anyway, Lordship. Just I came with my master.
Your name?
I am Digonto
Pal.
Haloi, Lordship.
Case number 7, in the forwarding. Page 20.
You, Mr. N, you, Mr.
And Kolita.
Heard Mr. N. Kalita, the Attorney Counsel, the petitioner. So heard Mr. E. Porter, the done additional PP, applying on behalf of said application in section so in connection. Is submitted by Mr. Kalita, that representing the petitioner agents. He is no way connected in the with the fact that on the day of incident, in the place of occurrence, he was present along with his master as who was whose master as he was driving his car. That apart, there is no such involvement of the present petition. However, the petitioner is in custody since when did you got you arrested?
27 to 26.
Since 27 to 2026, he is in custody. And hence, there was sufficient opportunity to interrogate him, keeping him. Further, he submitted that the three of the co-accused persons have already enlarged on bail. And enlarged on bail post a while, disposing bail petition of one PEDIC Vedic Modi, MODI Modi, PEDIC Vedic Modi in bail application number 635 of 2026. It has been observed in the number 7 that there was no such injury except some laceration in his head, and no firearm was also recovered at the time of the incident. However, the petitioner is still ready and willing to extend his cooperation in the further investigation of the case if it is granted with privilege. Mr. Porter, learned additional PP submitted investigation from the order passed by the learned trial court, the order passed by the coordinate bench of this court, honorable coordinate bench of this court, the service from the fire as well as from the boarding report. It reveals that the incident had happened, and the informant also sustained injuries on his head. More so, they also showed the firearm at the time of snatching the chain. Mr. Botapur accordingly insisted to call for the case diary. Next, considering the circumstances of this case, observation made by the coordinate bench of this case, especially in para 7 of the order, which reads as it is of para 7 to it says so and so. So considering the gravity nature of injuries sustained by the learned counsel for the by the accused petition, vis-a-vis the period of detention already undergone by the petition, find that further custody interrogation may not be necessary for the purpose of investigation, and that apart also considering the case of the present petitioner in the same footing along with the other accused persons. Court is of opinion that privilege of bail may be granted to the present petitioner. Accordingly, so and so steps prohibited to the satisfaction CGM company. That acceptable. Okay,
Acceptable.
Wait, so in this case, initially the informant side attacked us and we sustained grievous injury, so we lodged an FIR. Hereafter, they lodged an FIR against us, saying that we had attacked them. Now, in that case, we came before this honorable court. This honorable court granted us interim protection. So we took the interim bail order, went to the police station, and then found out that their side had lodged another FIR against us. And so police arrested us, and for the last 25 days, we are in custody, madam. But sections, they have invoked 109, so perhaps your lordship will want the case diary. Considering these aspects, may I pray for a shorter date, madam?
Yes, can it be on 19th? 19th you want?
My lord, if possible, my lord.
If possible,
25th,
that's what.
24th.
Okay. From where it has to come?
Yes, for
Tasteful, my lord. Otherwise, my lord.
Can it come?
25th, 24th.
No, if you want to give prior to a shorter date, in that case, 19 is the only date, but I don't think 19.
Please, 16th may not be possible. Lord, next week,
Possibility
my
is
lord.
less possible.
24th.
24th, my lord. I'm deeply okay.
24. ठीक है. Yes.
While it is in application 483, I am behind the bar since last, my lord, 100, 143 days, my lord. What happened, my lord? I was granted bail by the London Session Court, my lord, before charge sheet, my lord. And after charge sheet, my lord, I had no knowledge that it has been charge sheeted and there was issued a summons, my lord. Then, my lord, when I got the, I could not attend earlier, my lord. Then, my lord, I appeared on 20th, page 27, kindly peruse, my lord, page 27. I appeared on 20th of September through my lawyer and I filed an application accused Mosbot Ali absent with steps, petition number, which is rejected in view of pending warrant of arrest. Earlier warrant of arrest was issued against me, I do not know. No report received from the NBW issued. Even no report also has come, my lord. Just I knowing that I have come, I have appeared, my lord, through my lawyer, but my application was rejected, my lord. And thereafter on 16/3, I was taken into custody, 16/10, my lord.
1610.
25/10. So since then, 143 days, I am behind the bar, my lord. I am ready to face the trial, my lord. I will appear regularly. As Allah would have it, but I had no intention to avoid the trial, my lord. Lanet court has sent the non-bailable warrant immediately. In spite of the fact that I have made an application through my lawyer, it was not accepted.
Your lordship may kindly peruse page 35, my lord.
That is the last order, rejection order, my lord. Heard learned counsel for the both sides pending. I have considered the rival submission. I have also gone through the case record. On perusal of the same, it is found that the order 16/525 in NBW was issued against the accused, failed to complete his appearance in spite of the repeated strict direction by the order dated 8/11/24 and 18/2/25. Though the case was committed to in the year 2023. On the strength of the NBW record, the Mobaz Ali was arrested on 25/10 and remanded to judicial custody. So, my lord, I am behind the judicial custody.
Case is under section 302 and 201, my lord.
Yes, yes. 302
Only because of
has
his
been
non-appearance,
added
case was
restriction.
pending since long, my lord. Thereafter, on the strength of NBWA, the present petitioner was arrested.
Under any condition, my lord, if required, I will appear. If I miss to appear one day, my bail may be cancelled. That condition will be given.
At least a scan copy of TCR 302 and 201.
Then 302, but it is committed. Prima facie, there is a case against me. Where committed, it is a charge sheet has been filed. Case has been committed to the session court. So there is a prima facie case. Now scan copy will of no use, my lord.
Only because he has not appeared since 2023, my lord.
I was
Matter
not served with any copy.
matter
There is
was
no
pending.
reflection that someone was issued. Non-bailable warrant issued. Before that service, I have appeared before the court with the prayer for adjournment, but court has rejected my prayer and non-bailable warrant was in force, so I was taken into custody, my lord, on 25/10/25, and since then I am behind the bar.
Only because, my lord,
He
he has
absent
received
since when?
the summons, my lord. Thereafter, through his counsel, he has appeared and submitted application, my lord, before the trial court. But thereafter, only he has submitted the application, but he has never appeared before the.
No, that day I prayed for adjournment through my lawyer,
Since
brother.
when he remained absent without step,
My lord,
or when NBW was first issued.
yes. Page 27 is the order, my lord. On that day, he was appeared through his counsel, my lord.
Page 27 is my application on that day. My lawyer appeared and prayed for adjournment for further appearance. But court has rejected in view of pending warrant of arrest is in force. no report is received from NBWA issued against the accused Mohammad Ali, issue fresh WA and also issue notice to the bailer on 7/1/25. But before that, I appeared, my lord.
First order, my lord, 17/7/23. That is after filing of the charge sheet.
Till now, my lord, there is no progress of the trial. Trial has not yet started, my lord. Other co-accused are still absent. Pre-trial punishment, my lord. I admit that there is a fault on my part, and for which I beg apology also on behalf of my client.
Heard Mr. N.C. Biswas, the learned counsel for the petition. Also heard Mr. P. Waterford, the learned additional PP, appearing on behalf of state reform. It's an application and circumstance. It is submitted by Mr. Biswas that the present accused petitioner was earlier granted bail before filing of the charge sheet. But after filing of the charge sheet, he was not aware about any notice of the summons issued to him. And when he came to know about the same, he appealed to his counsel on the 20/09/2025 with an application seeking time for his appearance, but same was rejected on the ground that the NBW has already been issued against him. But he was not aware about any issuance of NBWA or someone against him. But and subsequently he got arrested on the strength of NBWA issued against him. And since 25/10/2025, he is in custody.
Statement
For last 140 days, the petitioner is in custody, and hence, considering his length of detention, he may be released on bail. However, he is ready and willing to contest the case by appearing before the learned trial court below, as and when the date is fixed. Mr. Waterford, the learned additional PP submitted in this regard that the sessions cases of 2023, and in spite of the several dates, the petitioner has not appeared physically before the court, and for which the NBW had to be issued against him. For his non-appearance only, the case was delayed. In disposal, and hence on the strength of NBWA, he got arrested on 25/10. Mr. Waterford accordingly submitted that considering the conduct of the accused petitioner, his prayer may not be considered at this stage. However, his scanned copy of the TCR may be called. Next paper, hearing the submission made by learned counsel for goods, I have also paid of the case paper, especially the order sheets filed along with the petition. It is the fact that the accused petitioner was earlier was on bail before filing of the charge sheet, and subsequently after issuance of NBWA, he appeared he appeared through his counsel seeking time, but that was rejected by the learned additional session judge Sri Bhumi, as NBWA is already issued against him. However, considering all aspects of the case, as vis-a-vis considering his length of detention already undergone, to stop that further custodial detention may not be required for the purpose of trial. In view of this, I find it efficacious to extend the privilege of bail to the present petitioner with a direction to appear before the learned additional session judge on each and every date to be fixed by the court, and to contest the case. Cover satisfaction as a learned additional session judge Sri Bhumi to the satisfaction demand 50,000.
Additional session just come, Korimganj.
Shrivam.
May I please ask? My lord, there are 4 petitioners before your lordship where they have been apprehended in the custody now since 9/3/2026. My lord, this is a classic case of, my lord, misuse of power by the authority concerned, or maybe a classic case of appeasement by the authority concerned. Well, no case has been made out. Still, these persons, they were put in the custody. The materials has been seized. Now, initially what happened, my lord, page 22 is the FIR. What happened, my lord, there is some dispute arising out of a parking of a truck which contains some flyers or leaflets, and all this person in a commercial, my lord, in a residential complex, they wanted to park it inside the residential complex, my lord, this truck, which contains some flyers and the pamphlets, my lord. Now, during to sort out that dispute, my lord, police has arrived, and after arriving in the spot, they have found that that truck, it has contained some leaflets of a particular political organization, which is against one particular person, my lord. The leaflet contains the material. They said it is a search sheet against the Chief Minister of Assam, that leaflets. And those leaflets has already been circulated by that political party in a press meet prior to the seizure of this material, my lord. Now, lordship, kindly see these pamphlets, it's not been distributed, just it was placed inside a truck in a parking lot of an residential complex. And what are the material and what is the allegation, lordship? It is absolutely, my lord, I'm stunned how they can seize this material and put the person behind the bar for the offense, my lord. The offense has been registered. This is also very case of a, my lord, kind of a sedition in an earlier act, my lord. Now I'm coming back to the page 22, how the authority is acted. Lordship will be surprised to see how the material is connected, my lord. The undersigned, page 22, I'm reading, my lord, the FIR. FIR regarding the organized printing. I have, for the first time, I have come to a word organized crime I have heard about, but the organized printing, I couldn't find out what is the meaning of organized. Probably they wanted to say organized crime. The printing, possession, transportation, and proposed distribution. This is very important. It's not been distributed. It's a proposed distribution of provocative and the false election-sensitive posters. If it is an election-sensitive poster, with intent to create disturbance in the public disorder and electronic disharmony. I understand to hereby lodge the complaint towards the immediate investigation into the grave and organized affecting the public peace, electoral integrity, and law and order in Assam. I have honored to report during the regular patrolling of the so-and-so, dated so-and-so, call to receive and so-and-so, stating some arguments were taking place at so-and-so, housefed apartment near Pipco Point between some society member and some other person related to the commercial vehicle that had entered into the campus. Accordingly, OC so-and-so arrived at the place of occurrence and also called the additional OC and me along with the staff to the spot. It is also maintained that it was in the duty in charge of the so-and-so at time. Later, situation was controlled without applying any force. Situation was controlled. However, some society member alleged that the said vehicle was carrying leaflets of a political party and they suspect that the bundle might contain the provocative. They suspect only provocative slogans which could disturb the communal harmony. According to the OC, this person instructed me to take the further necessary action and cause inquiry into the matter. Accordingly, the vehicle bearing so-and-so was seized along with the 330 bundles of the leaflets and Pearson 250 bundles of leaflets also seized from the flat number so-and-so. Later, the seized article along with the vehicle and the below named person were brought to the PS further erection and necessary legal action. The seized vehicle along with the seized article had been kept in the GMC parking under the police escort. During the course of inquiry, the said posters are written. This is very important, Lordship. Kindly mark it. in SMEs and prominently bear the headline equivalent to the charge sheet against the chief minister, followed by several highly inflammatory and scandalous and provocative imputation intended to erroneous resentment, anger, disturb, and hostility among the general public. And the plain reading of the said material, it contains not only the nature of the fair comment, ordinary political criticism, and a lawful democratic dissent, but are couched in a form designed to sensationalize, inflame patient, provoke public unrest, and disturb the atmosphere of the immediate proceeding forthcoming Assam state election expected in the next month. The timing, scale, language of the made at the decision clearly indicate the deliberate and concerned design to influence and disturb the electoral environment of the circulation, unverified and inflammatory allegations among the electorate. Whether it is make out a prima facie case, I'll come to that, my lord. The very fact of such erroneous quantity posters exceeding 10 lakhs copies was printed and kept ready for distribution. It's not distributed. Demonstrate prior printing, organized financing, coordinate for unknown person acting in concert. The scale of operation itself rule out any case when so I shall prima facie suggested systematic campaign to spread falsehood, incitement, and public mischief in a mass scale across the state of Assam. The said posters contain the imputation and assertion which is in their tenor and represent are capable of creating the enmity, hatred, ill will, distrust, and public disorder, particularly in a political sensitive period when the election run high and even single provocative publication can trigger a local tension, confrontation, retaliatory, so-and-so, public property breach and piece of electoral disturbances. The matter of the recovering the surrounding circumstance strong suggests that the poster were intended to immediate distribution and public display multiple location of Assam. There, the clandestine transportation and the absence of disclosed published particulars, permission detail, account particulars, lawful authorization and the campaign material are additional circumstances showing to cover malified operation during the urgent custodial investigation. So it should be proper investigation assert in the publisher, financier, consignor, assignee, house owner, transporter, local handler, and the intended distribution network which is intended to create the law and order issue in the Assam and the particular in Gauhati. Now they have registered this case, my lord. Lordship kindly see what are the section, my lord. 152, then 157, 175, sorry, 196, 197, 353, and 61 of the Bharatiya Natya Samhita, madam. Now, Lordship, kindly to bear me for some time, my lord. Lordship, kindly see those provisions, my lord. I know Lordship has gone through many a times. For my consideration, my lord, Lordship, kindly take the provisions one by one. Now, first, the main two provisions are more important, that is 152. And it was earlier in the IPC, it was 124A. Now 152, what is the material? Lordship, kindly see what is the requirement to make a prima facie material. Whoever purposely or knowingly by words either spoken or written or by signs or by visible representation or by electronic communication or by use of financial mean or otherwise attempts to excite sessions or armed rebellion, subversive activity, or encourage feelings of separative activities endangers the sovereignty or unity and integrity of India. That is the requirement. The sovereignty and the unity of integrity of India, or indulges in or commits any such act shall be punished with imprisonment for a life or imprisonment term which may extend to the 7 years. So what is the requirement? The first requirement is the separatist activities which endangers the sovereignty or unity of integrity of India. The first line says the act endangering sovereignty and unity and integrity of India. This is the pamphlet. Admittedly, they said it was against the chief minister. He is not the India nor the government, pilot. He's just the chief minister. He cannot replace the terms of India, my lord. That has been settled proposition long time back, my lord. Now, the next, Lordship kindly see, next section important is 175, my lord. This is bailable, my lord. If it will 175, the false statement in connection with an election. This is an bailable offense, my lord. Whoever with intent to affect the result of an election makes, publishes a statement purporting to a statement of fact which is false and which either he knows to believes to be false, does not believe to be true, in relation to the personal character or conduct of any candidate shall be punished with fine. My lord, still the election was not declared when they were arrested. So the against any person, he may not be a candidate before the declaration of the particular. When it was they have said, arrested, the candidature of this particular chief minister was not being, my lord, finalized till today, my lord, even. So this 175 also does not come, even if we say something against a person, because it has to be a person who stood in the election. Only then 175 will come into play. Next provision is 196, my lord. This is promoting enmity between two different groups. First requirement is different group. Here is no different group, my lord. Only against one person. On the ground of religion, there is no question of religion here. It is only one. The first requirement, it has to be between two groups on the grounds of religion, race, place of birth, residence, language, etc., doing act prejudicial to maintenance of harmony. But the requirement is that it has to be, first of all, there has to be two groups. Even a one group will not act this 196. And it has to be in the grounds of religion, race, place of birth, residence, etc., language. Here, absolutely nothing to that effect. This is an insinuation maybe against one particular person. Whether it will create an offense under 190, 152 or 196. Next one, my lord, 197, my lord. This is also 3 years punishment, my lord. Imputation, assertion, prejudicial to the national integration. The requirement of against lordship will find, 1, whoever by words, either spoken or written, or by sign of any visible representation, or through electronic communication or otherwise, A, makes or publishes any imputation that any class of person, my lord. The requirement of this is that the class of person. It has to be against a class of person, not as the individual entity, my lord. Cannot by reason either being members of any religious, racial, language, or regional group, or caste or community bear true faith, or either. So it has to be against a class of person, my lord. Either may be a religious or communal, or bear a true faith, allegiances against the Constitution of India, then this particular 197 also will come to in place. But here, absolutely no material at all. This is a publication already published against a one person, my lord. Where is the class of person who is believing, who's their religious entity? It has to be class of person who is following a religious, racial, language, religious group. That is the only difference between the 197 and the 196. 196, there has to be two groups. 196, there can be a one group, but there has to be a class of that person forming that particular group who may be a religious or racial group or linguistic group. If we say something against that, then maybe 197 will come. But it has to be a group of person who are maybe a religious or racial. So something has to be there. Some imputation against that group following a particular religion, following a particular racial group or language, then it will come into play. B also, the asserts, counsels, advises, propagates, publishes any class of person, again, the requirement B also class of person, C also class of person. My lord. The requirement that has to be a group who are following a particular religion, maybe following a particular racial or linguistic group. If we make, or community, if we make certain assertion which is prejudicial to that particular group, then the 197 comes. It is 5 years, my lord, in case when it is a religious worship. If we make it in a religious worship, then it will make a 5 years. Otherwise, it's a 3 years punishment, my lord, maximum. And 197 and D also, who publishes misleading information jeopardizing the sovereignty, unity, and integrity of India. So it has to be against the India, not against any individual. A chief minister cannot be in India. Earlier, Indira may be India, but now Indira is no longer in India. Anyway, jokes apart, my lord. Now, the last one is the 61 is the lordship. No, that's a conspiracy, my lord. So this is the penal provision, my lord. So these are they have already seized. This was not even circulated, admittedly. This was only being seized. If it was not circulated, just they have kept it inside a house, because the requirement of this, it has to be circulated. It may be a case of defamation at best, my lord. If the remarks are, if he feels against whom, probably the person who has against whom this is made, he is also not concerned about this. This is sometimes what happens. Sometimes some people acts to please, to appeasement. So now, lordship, the next proposition, my lord, if there is a 152, if we go, if there is no 152, the requirement is the notice to arrest those persons, my lord. To bypass the 152, bypass the notice, my lord, rather, earlier 41A notice, lordship knows it, 7 years punishment notice is mandatory. To bypass that provision, my lord, they added the 152. So 152, lordship, kindly see again whether the 152 comes. My lord, two judgment, the landmark two judgments of the Supreme Court, and way before, considering this kind of situation, has already two full bench judgment, my lord. And in 1962, I am reading, my lord, this is the provision. Here in the earlier, my lord, it is 124A, which is now 152, my lord. The lordship straightway can go to the provisions, paragraph 24.
1962.
1962, my lord. Kedarnath case, my lord. In this case, we are directly concerned with the question of law, part of defense offense as defined 124A of Indian Penal Code, which is consistent with the fundamental right guaranteed under 19(1)A of the Constitution, which is these in terms. Now, initial part is not, they have distinguished what is 124 and 505 of Indian Penal Code. Now, I'm reading from the 19(2), my lord. Nothing in subsection clause A of the clause 1 shall affect the operation of any existing law, prevent of the state from the making any law, insofar as the law imposes reasonable restriction on the exercise of the right conferred by the said subclause in the interest of the society, scrutiny of the state, friendly relation, foreign state, public order, decency and morality of the relation, contempt of the court, defamation, incitement of the offense. My lord, illegally, these provisions was challenged before the Constitutional Court, whether 124 can be construed as a constitutional provision or not, or it is violative of the fundamental rights. So the Supreme Court has said, no, it is not a violation of fundamental rights. But with that, what is 124 has elaborately discussed. Now, from the middle, my lord, I'm just reading, I'm not taking much time. The decency, morality, so all this section has been quoted. How far the consistent and requirement of the in Article 19 of the particular reference to the security of the state and public order section, it must be noted, penalize any spoken or written words or sign or visible representation, etc., which have the effect of bringing or which attempt to bring into the hatred or attempts to excite the defection towards the government, my lord, established by law. So originally, my lord, it was the British has propounded this principle, but later on it was also taken by our constitution. Now, the expression the government established by law has to be distinguished from the person for the time being engaged in carrying out the administration. Government established by law is a visible symbol of state. The very existence of the state will be in jeopardy if the government established by law is subverted. Hence, the continued existence of the government established by law is an essential condition of the stability of the state. That is why sedition as an offense in section so has been characterized, comes under the chapter so relating to the offense against the state. Hence, any acts within the meaning of 124A which have the effect to subverting the government by bringing the government into contempt or hatred or creating the dissatisfaction against it would be within the penal statute become feeling of disloyalty to the government established by law or enmity to it, importing to the idea of tendency to the public disorder and the use of actual violence of the incitement in violence. So it has to be against the government, my lord. But here, Lordship will see this allegation specially directing to one particular individual, not to any government. Absolutely against one particular person, man. Now, in other words, any written or spoken words, etc., which have implicit in the idea subverting the government in violation means which are contemporaneously included in the term revolution has been made penal in the section question. By the section has been care to indicate clearly strong words used to express the disapprobation of the measure of government with the view of their improvement in the alteration by the lawful means would not come within the section. Similarly, the comment, however strongly worded, expressing disproportion of the action of the government without exciting those feelings which generate the inclination of the cause of the public disorder by act of violence would not be penal. So it has to be maybe very harsh, but it has to be without the feelings of general the public inclination, cause of public disorder. It cannot be 124A, madam. Here the pamphlet says against what? I don't want to read in public, my lord. Lordship has gone through that pamphlets. This is nothing but against one person, my lord. And it was earlier, it was released in the press release itself, 7 days prior to this publication, my lord. The seizure, it is already released. Nothing had happened. By press meet by the party itself. Just to stop for the distribution of these pamphlets, my lord. And they have admitted that the election is coming out. My lord, during election, if the pamphlets are banned for with the grab of 124A, then Lordship kindly see what will happen. Next one is the next judgment, Lordship shall see, my lord, 1997. Then the Chief Justice A. Anand, 153A, and the paragraph 6 and 8. No? 6. A decisive ingredient to establishing the offense of sedition under section 124A IPC is doing of certain acts which bring into the government established by law in India hatred or contempt, etc. In this case, there is not even a suggestion that the appellant did anything against the government of India or any other government of the state. The charge frame and so and so contains no avertment so and so so and so. So it has to be again against the government. Now paragraph 10 also important, 153A, which has been now 153 here, which is 196 now, my lord. 153A amended by the criminal and election laws amendment so and so. It consists of 3 clauses, which clauses 1 are not material now by the same amending so and so so and so so and so so and so. Now paragraph 11. The court has held in the Balwant Singh Bhatt state of Punjab. That means mens rea is necessary the ingredient for the offence under section 153A. Mens rea is equally necessary to postulate for the offence of the 15052. Also could be discerned from the word with the intent to create the promote, which is likely to create the promotion. The main distinction between the two offences is that while the publication of the words or representation is not necessary under the former, such publication is sine qua non for 505. Now discussing everything, 15 is most important, my lord. As I said, as I argued before your lordship, the 2 group is necessary. The common feature in both the sections bringing promotion in of feeling of the enmity, hatred, ill will between different religious or racial or linguistic or regional groups is or caste or communities. It is necessary that at least 2 such groups or communities should be involved. Where is these 2 groups, my lord? To bring that particular 196, as I said before, from the statute itself, 2 groups is necessary, either may be religious or linguistic, but 2 groups is necessary, my lord. As the Supreme Court has also, the paragraph 15 has elaborately considered that the 2 group is necessary. Here, what is the allegation? That some pamphlets has been recovered inside a truck or inside a room of a particular building, which bears some of the insinuation against one person. Admittedly, they said against the Chief Minister of Assam. How these offences has made out, my lord? And for that purpose, it was not even distributed. They have seized everything now. Their purpose is over. They have seized the 10 lakhs of copies of this alleged charge sheet, my lord. Their purpose is over. Now, the second point is, my lord, here, now in regarding the notice also, my lord, it's a defective. All 48 notice being served to one person who is no way connected. The lordship kindly see the person name and the person arrested. The 4 person being arrested, against all the 4 person, one particular person has received the copy. One Abdul Motin, he has received all the notices for Akshay Kumar, everybody. And apart from that, my lord, they were produced on that day about, my lord, 3:30. These people were produced in the 41st day about 3:30 on 9th. And the notices on served to us, that is on 2:30, just 1 hour prior to our production before the court. And lordship knows there's a clear judgment of the Supreme Court to that effect. At least 2 hours prior, the notices needs to be served to the designated person or to the relative, my lord. He is not a designated person, my lord, or to the relative, my lord. So considering all this material, my lord, lordship kindly consider our bail application, my lord, or if lordship feels that the case diary is necessary, then kindly give us the interim protection, my lord. Definitely, my lord, the case diary will come, my lord, and it will show everything. But even with the prima facie material, they are already in custody for last 7-8 days. Now, they know offense has been made up. Prima facie here, my lord. Where is the sedition, my lord? If I write something against one particular individual, maybe he is holding a high post in the government. But it is not against the government. It is not against the India. It is against the person who is holding a public office. Simple as that. How can be it's an offense, my lord, of a sedition, that too. The highest order of punishment, my lord. That's why sedition been diluted, my lord, now. After this Kedarnath also been considered by the Supreme Court recently because of the misuse of this particular provision. This is still pending. And this is a criticism against one individual regarding him. How can it be a sedition? Not a single word against the government. The first requirement is there has to be government as per the Supreme Court judgment. The second requirement, there has to be two groups. Where is that? Not even one group. It's only one individual person. So I pray, my lord, they should be released on bail, my lord, today itself. Absolute violation, my lord, of democratic principle of this particular country, my lord, which is going on all over the country, my lord. A person has been arrested, put into bar for saying something like that, put into the NSA for 6 months, and then one night they will decide, no, we'll lift the NSA because they knows it that it's not going to stand in the court of law. This is what is happening, my lord. A scientist being arrested for making some statement, just making some statement in an NSA, my lord. And they have suddenly withdrawn that NSA. Here also, Lordship can see how this the section, my lord, they have registered 152 and 197, 196. 192 is a sedition. What is a single, not a single word, my lord? They say that during the side of inquiry, the said poster are written in SMS and prominently bear the headline equivalent to charge sheet against the chief minister. Simple as that. They are admitting it's a charge sheet against the chief minister. How can it be a sedition, madam? How can it be a conflict interest between the two groups, madam? If it is a election also, then 175 we are making, that's a bailable offense. That's too premature, madam. If it is considered only is the defamation, madam. For defamation, they have to file the complaint. Their primary requirement to seize the material, madam. That was the primary requirement. That they are already successful, madam. They have seized all the material, madam. We don't know when we will get the material released, madam. And when the material being seized, they are no longer, their detention also necessary, madam. And the learned trial court, without going through this provision, simply remanded back, considering that this is a sessions triable case because the 197 we cannot exercise. This is the judicial exercise in the trial court. Just because the blanket order I cannot deal with because it's a sessions triable case.
Yes, but
I would just like to, my lord, first, my lord, point out, your lordship may kindly come to page 22 of the FIR. I would like to read again some of the relevant. Page 22 from the FIR, my lord. I would like to read some relevant paragraph already pointed out by my lord, learned senior, my lord. I am for your lordship may kindly come to, my lord, during the course of inquiry, my lord. That is just now pointed out.
Yes, yes.
By my, during course of inquiry, the said posters, my entire dispute is regarding that leaflet, and that leaflet is not at present, my lord, with us. And from that leaflet, my lord, what are the contents of that leaflet, my lord?
Already, which is
From that leaflet, my lord, this my lord, this FIR, contents of the FIR is available in the present FIR. My lord, I would like to point out first, my lord. During course of inquiry, the said posters are written in Assamese and prominently bear the headline equivalent to search sheet against the chief minister, followed by several highly inflammatory, scandalous, provocative imputation intended to arouse resentment, anger, distrust, and hostility among the general public. My lord, post of chief minister is a constitutional post. From those, my lord, members of legislative assemblies were selected by the people of the state in a
go by the law, by the act, don't go by the political
in a
lecture. We don't.
democratic manner. So I am just trying to point out the post regarding the post of chief minister, my lord. That, my lord, from amongst the democratically elected, my lord.
If he can show as a government, my lord, I'll concede, my lord. He can show the chief minister is a government.
So post of peace. So post.
He is not a government, my lord. He is not in India.
So post of chief minister is a respectable post
Yes.
amongst the members of the legislative assembly on being consensus, my lord, one person.
Your
was
post is
elected
also
as the
very
post of chief
respected
minister.
post.
Yes, my lord. That is why I am pointing out the
Yes.
post of chief minister is a very respectable post, and the post is my lord, he is holding the post on being constitutionally selected by the my lord through election, my lord. He is democratically elected by the people of the state, my lord. Then that on a plain reading of the said material, the contents are not in the nature of fair comment, ordinary political criticism. So these are not, my lord, fair comment, not ordinary, my lord, ordinary political criticism, my lord, or lawful democratic dissent, not also, my lord, any lawful democratic dissent, but are couched in a form designed to sensationalize, inflame passions, provoke public unrest, and disturb the atmosphere immediately preceding the forthcoming Assam state election expected next month, my lord. The timing, scale, language, and mode of dissemination clearly indicate a deliberate and concerted design to influence and disturb the electoral environment by circulation of unverified and inflammatory allegations among the electorate. So by way of, my lord, by way of, my lord, printing and, my lord, intent to, my lord, distribute all those leaflets, my lord, and from the contents of those leaflets, my lord, this affair is written, my lord. And from that, my lord, it reflects that these are the, my lord, provocative, my lord, these, my lord, statements, my lord, these are not going to affect the, my lord, unity and integrity of this nation, my lord. If any act or offense which affects the endangering, my lord, sovereignty or unity of the state, that will ultimately affect the sovereignty and unity and integrity of India, my lord. So these are the, because of these statements, my lord, these materials that are the contents of that, my lord, leaflet, my lord, ultimately under the provisions of section 152, my lord, case has been registered against the present petitioners, my lord. So, my lord, from the contents of the present, and thereafter, my lord, while the petitioner also approached before the trial court 2 times on 9/3 and, my lord, 11th petitioner bail petition was rejected. There is, well, at that point of time, my lord, regarding those in the, my lord, because the copy of the, my lord, bail rejection order is not in the petition, my lord. So, my lord, whether at that point of time, the trial court has discussed, if there is no ingredients of section 152, then definitely, my lord, trial could have, my lord, granted bail at that point of time itself. There is no bar if the
Yes,
ingredients of
my lord, I
section
was
152 is
expecting
not
this.
here, my lord. And, my lord, at this point of time, my prayer before your lordship, considering all these allegations and from the leaflets, my lord, and election is also forthcoming. So my prayer before your lordship to discuss in detail and, my lord, to point out everything before your lordship, my lord, any sort that may be fixed to produce the case diary, I will produce the case diary, my lord. And, my lord, today my prayer before lordship at this point of time, considering the, my lord, materials, my lord, prima facie materials from the contents of the affair, my prayer before lordship, no interim may be granted at this stage. My lord.
That order says, my lord, only because of the, it's a sessions tribal case, my lord. We have marked it that with the highlighter, my lord.
And regarding, my lord, section 48, my lord, notices were served to, my lord, one Abdul Mutin, my lord. Whether he was, my lord, nominated by the present accused, whether
No, that will come in the case diary, whether it is, I'm not on that, my lord. But the prima facie prior, that will definitely come out whether we have nominated Mr. Martin, designated Mr. Martin to receive. And that designation has to be there, my lord, in writing. That is definitely, it will come before the case diary. I'm sure we have not designated. That is my instruction. That's why I'm saying that even the 48 not all been properly served. But as he is saying, it was against the chief minister. We are not denying that. He said the chief minister is a constitutional place. Who is denying that? But he is not the India. He is not the government. If he can show it that the chief minister is government or India as required by the penal provisions, then yes, may make it out. Yes, maybe. Sometimes, not in all cases, even though. Fair criticism against the government of India cannot be 124 or the sedition. That's also there. But if you take it as an yes, but first requirement is what? There has to be 2 religious groups, 2 racial groups, 2 linguistic groups to add this 173, 176. The first one, 152. What is the requirement? It has to be against the government. Where is the against the government? It is against maybe against the public. here the public may or may not. So under the apprehension, you will put me under the custody. They said itself that the plain reading of the said material contains not in nature of the fair comment. That is a fair comment is a case of defamation. Ordinary political criticism, that is also defamation, my lord, or lawful democratic dissent, but are clutched in a form of design to sensationalize, inflame, passion, provoke the public unrest. Where is the case of public unrest here? When we are making an allegation against one individual, where is the concept? That's why the Supreme Court in the 1962 itself, in Kedarnath's case, is very categorically says that I am reading it once again for benefit of my learned friend, so that he can understand what is government and what is the chief minister. The use of actual violence or the indiscriminate, in the other words, the written or spoken word, etc., which have implicit in the idea of sovereignty, subverting government by violation means it has to be government, which are included in terms of revolution, which has been paneled by the section in question. But the section has been clear to indicate clearly that strong words, use of express disproportion of the measure of the government, with a view their improvement and alteration by lawful means would not come into this section, even if it is against the government, but if it is lawful, if we can criticize the government also for their work. In that case also, the 124A will not come if there is a fair criticism against the government. But it has to be against government, whatever may be. Where is the government here? Sometimes they are acting more loyal than the king to show their appeasement to a particular person. That look what we are doing for you. This is nothing but more than that, man. They have become more loyal than the king. Everyone has become more loyal than the king to show that what they're doing, actually doing. Yes, you did a very good job in a democratic country. You seized the material, your job is done. That's why, my lord, that's why this election purpose also, the second judgment also deals with that purpose also during, because that is related to election itself. They are also saying that during election. So you are concerned about the fact that during election, that what is the purpose behind of seizure of those material, madam. So definitely these material already been seized, they are saying it, and the forwarding report, the grounds of arrest, lordship, kindly see the same material, what they have found, the same material in the forwarding. Where is this edition, my lord? Page 24, my lord. The grounds of arrest. Number 1, in connection in so-and-so, 4, Pranjit Ware, Rakibul Haq, Jainal Abidin, Akshay Kumar Bordoloi, and Pranjit Patar were found involved in the possession, transportation, holding of a huge quantity of provocative and inflammatory election-sensitive poster. It's an election-sensitive poster, man. Where is the against the government? Where is the sedition, madam? During the routine patrolling so-and-so, police received the information regarding the so-and-so apartment, PIPCO reaching so-and-so, large quantity of printing pamphlets, so-and-so were seized from the platform of so-and-so. Examining the seized pamphlets found that the contents provocating inflammatory and scandalous allegation under the headline "Charge sheet against the chief minister." Where is the government, my lord? Where is the India? Which are capable of disturbing public tranquility in the electoral atmosphere. It may be a case of election, violation of the election rules, my lord, at best. And the reason for arrest is very peculiar, my lordship. Kindly see the reasons of arrest. We have been arrested, my lord. That he may tamper with the evidence in the case in any matter whatsoever. He means singular. He may be any threat, inducement, or promise to any person acquainted with the facts and circumstances. You have already seized the plain page. He may disclose the fact truthfully without the concealing the part of the relevant for purpose of the investigation. He may destruct the evidence relevant to the purpose of investigation trial. And there may be every possibility that he may be disappeared from the location. It even does not say that this seizure material will create the disharmony between the two groups or disharmony in the government. Nothing. So that's why I'm praying, my lord, they should be released immediately with an interim bail, my lord. And lordship may collect the case diary, call the case diary at any day, my lord. But they should be released because it has to go, a strong signal must go from the judiciary so that the fate of the judiciary can be reposed again, my lord. These are the time, my lord, when we have to act in accordance with the law, my lord. These are the crucial time we need to, because this is an absolutely violation of the democratic principles of this country. People, simple leaflet, publishing a leaflet is sedition without saying anything against the government, anything against the country. This is absolutely, my lord.
Well, I would just like to point out one thing, my lord, regarding that headline, that is only a headline, my lord. That is only a headline. The contents of the, my lord, leaflet, my lord, that is.
They said what is the contents?
That is not with me, my lord. And
They said, your paper said the
Because
contents.
of those aspects, my lord. And I would like to again point out, because in that regard.
If there is nothing in the content,
well, again, I would
if
like
there
to
is something in the content, why you have not incorporated in the FIR itself?
Let me submit. I would just like to point out, my lord. Your lordship may kindly grounds of arrest, my lord.
Yes.
Ground number 1 regarding that, my lord, handling of a huge quantity of provocative inflammatory election sensitive poster intended
Yes,
for
I have
mass.
read it. Election
If those
sensitive poster.
contents are election sensitive
Yes.
posters, my lord, that
That is the sovereignty of this country.
yes, my lord, it will directly affect the electoral process, my lord.
Electoral process
Ultimately,
is not sovereignty, my dear friend.
My lord,
Sovereignty is
ultimately, my
different.
Ultimately, my lord, suppose, my lord, from the, I would, my lord, because of that reason, my lord, I am praying before your lordship, my lord, at this stage, because today matter is listed for motion from the contents of the FIR and forwarding report I pointed out to your lordship, my lord. What are those, my lord, and their trial court also, my lord, rejected 2 times. So any sort that may be fixed, your lordship may kindly call for the CD, my lord. While matter.
I am not objecting to the calls for the CD, my lord.
Without
I am
granting any
only
interpretation,
objection, my lord. They are
CD.
saying that the election is a sovereignty. I am flabbergasted by this opinion of the public prosecutor that nowadays election become a sovereignty of this country. Absurd proposition, my lord. How election is connected with the sovereignty of the India, my lord, or the government is concerned? How this 124 comes into play into this case? What is the requirement? Where there's two community you have indicated in the FIR? In the FIR also, my lord, just the election. It is for the purpose of election you are distributing. That's why we will seize the material. It's a sovereignty, it's a question of the sovereignty of the country. But there's not a single word in your FIR itself that something else is there apart from the allegation against the chief minister. Your own FIR says it's an allegation against the one individual, against the chief minister. There's nothing in the FIR. I have placed the material before your lordship also. What is the pamphlet? It will definitely come along with the case diary. That's why I'm saying, give us the interim protection, my lord. It will not take out, my lord, anything from us, my lord. If there is material, definitely we'll surrender again. If you can satisfy that, yes, this is the material, it goes against the sovereignty of this country. Now the sovereignty of India has so fragile that the only election purpose is something they say, any comments, it's become a sovereignty. It's become so fragile and weak. Yes, we can understand it has become so weak because some other countries are making or allowing us or giving us leeway to bring oil from other countries. We have to take permission. Yes, that's why probably my friend is saying, yes, this is related to sovereignty. We have become so weak We have lost our sovereignty. If that be so, I'm grateful, my lord.
Well, election is the only process in our country, the huge process only.
That is a democratic
Well,
process and democratic way
We said
that has been
democratically,
published
yes,
7 days back. These pamphlets were published 7 days back by a political party in a press release. You did not do anything at that time. No FIR, nothing. Everything in the internet it is available. Nothing. That's why they have also registered the case under the IT Act. These pamphlets are available. Flyers are available. In the, below also, Lordship can see there's a scanner that's already available in the internet. That's why I'm saying, my lord, to establish the rule of law, my lord, Lordship, kindly consider our interim prayer, my lord, at this stage.
I'll pass the order.
Obliged.
Yes, ma'am.
Obliged.
That's what my daughter.
May I hand over this one, please?
You have gone through?
May it please your lordship, a simple case, not a page 13 is the FIR, Here, here, two stores were named, alleged that they were, they have sold some SIM cards, Now, the petitioner is not named, They have sold some SIM cards, This Xerox store and
SIM card.
SIM card, Xerox store and Punky store, are two stores, which allegedly they have sold some SIM cards. The owner of those stores,
How they stole the SIM cards?
These allegedly, they have sold SIM cards, which were used for some financial transaction. It is alleged,
Page 18, my lord, forwarding report.
Now, the owner of these persons are not before your lordship, They were, these persons, owner of are Moon Kolita and Konkon Kolita, They were also arrested. Now, the petitioner before your lordship, is Moinul Haq, Moinul Haq, he is employee of Vodafone, He's an authorized employee of Vodafone, I have annexed his identity card, Now, that's why he is arrested, And all the
At
offense
the
are.
time of selling those SIM cards and all, there was no verification.
It was there was verification, There was verification not done by me. I categorically stated, done by the Vodafone itself, not by me, And all the offense are 7 years and below, Though, and no notice has also been served upon me, before my arrest,
Yes, what? You are saying that you're selling the Vodafone SIM card.
I am not selling, two stores, Not a Xerox
From
store.
your store also.
No,
From your
not
store also.
No.
No, you are selling this Vodafone SIM
I am an
cards
employee of the Vodafone.
from employee.
I'm petitioner before your lordship with the employee of a Vodafone, Two stores, they used to sell, SIM cards, Xerox store and Punky store, the person concerned, the owner or proprietor of those two stores, Moon Ali and Konkon Ali, they were already arrested, page 19, They were arrested under the same forwarding report, now they are in behind the bars, your lordship. These were the owner of those two stores who were selling those SIM cards.
Yes, what?
Well, your lordship may kindly come to page 18 and regarding my lord, my lord, section 35(3), my lord, in course of investigation, the ground why section 35(3) has not been served, my lord, that reasons is also, my lord, there in the forwarding report, my lord. And he is the person, my lord, although he is not the, my lord, owner of that shop, my lord, Ponky store and Hirok store, but he is the person, employee of the Vodafone. He may be in the huge numbers of, my lord, SIM cards, my lord. So these persons, my lord, he in fact provided to the distributor, and thereafter, my lord, those SIM cards were used for various illegal, my lord, cyber fraud activities, my lord. So at this stage, my prayer before lordship, my lord, CD may be called. for.
There is no allegation as on date, that I have
The
sold
ground-
these SIM cards to Punky store and Iraq store,
Suspected, my lord, mobile numbers allegedly committing financial
And
fraud
those
or
mobile numbers,
and all
they were
and
not
during
direct.
investigation, my lord, specifically those SIM cards, my lord. Police detected that those SIM cards are specifically using, my lord, committing, my lord, financial fraud.
These have
but-
come from which place?
From
CID, my lord.
cyber PS.
CID, my lord,
CID.
Gauhati itself, my lord. And but petitioner has a 2-year-old
We
minor.
may try to give you on 19, but.
Can it be on 19, my lord? Because 24 to we'll have a try, my lord. If there is no CD, my lord, I won't press, my lord. CID, my lord.
Try once,
Yes,
be prior.
yes,
Lordship, I'm grateful, my lord. Obliged, my lord.
19(3).
My pleasure, your lordship. This is the anticipatory bail application. I am praying for bail, your lordships. There are two accused petitioner, your lordship, one of Shahid Ali and Atikur Rahman. In this case, what is happened, your lordships? One of Tohidur Rahman, he is a informant in this case, and also he is being an PDP party member. He alleged that on 1/3/2026, approximately 5 p.m. in the morning time, while the informant along with other friends were patrolling the river, Bang River, which is located in Lohargada under the jurisdiction of Mukalma PS, your lordships. And then the VDP members and the informant had seen that the FR named accused person were loading the 3 cattle into 4-wheeler Maxim van from another 4-wheeler vehicle. And when the informant asked about the accused persons regarding the fact, but they means, your lordships, as per FR named accused person, they could not reply about the incident. And your lordships, the informant confined the accused person, but one of the accused person fled away from the place of occurrence. That is the fact. So in this case, your lordships, you see FIR page 10. No. What is
Shahid
happened?
Ali?
May I submitting? There are regarding 3 cattle was theft, and accordingly, the 3 cattle has been seized on the day of incident that you find page number 21. Already been recovered. But I am praying for there are 2 petitioner. That petition number 1, he is being a driver on the day of incident, your lordships. He was carrying the said cattle in his vehicle. When he reached Loharkatha, thereafter the informant, other associate of VDP parties, they are demanding money, and which the petition number 1 refused to do so. They handed over the police of the petitioner, and accordingly he escaped from the place. And further praise that, your lordships, even if he knows about this about the cattle were stolen, then he could not carry actual fact. carry this cattle. This is the actual fact of the petition number 1. And your lordship's petition number 2, he is not FIR named accused person. FIR named accused person, otherwise he is not any whisper against any word in the FIR, which I'm paying for pre-arrest bail, petition number 2. And he is actually seller of vegetable, and his shop is situated at your lordship's Ganeshguri under
Why
this
apprehending?
apprehending his lordships as per forwarding report. You see, there are 5 accused person has been arrested and they are remaining jail. 4 and 5 he's the relatives. He's the relatives of accused number 2. That is why police is charging. But on the day of incident, he was not present. He was busy in business in the Gauhati. So I am praying for bail, your lords, anticipatory bail. So recovered part has already been over, and your lordships, tea kettle has already been seized. The FIR named accused person, which already been arrested, 5 accused person has been arrested. So further custodial interrogation may not be required at all, as because petition number 2, he is not FIR named accused person. As per FIR, you've gone through, your lordship, that you find page number 11. May I read, your lordship?
No need to read. I have it.
So in the meantime, your lordships, kindly interim mail may be granted, your lordship. CD may be called for.
Your lordship may kindly come to page 20, my lord. And regarding here, during submission, he my lord admitted that those accused persons were present at that point of time, and they fled, my lord. And some other accused persons who are FIR named, who were caught red-handed and thereafter handed over to the policeman. And page 20, my lord, regarding some other accused persons who were at that point of time caught red-handed, my lord. One, Biju Ahmed, he is involved in, my lord,
Yes. Oh, yes.
5 other, my lord, cases, my lord.
Yes, 5 accused has already.
Bedur Rahman, he is also, he is all these 2 petitioners were associate of all those, my lord, accused persons.
No, yeah, as per ground of arrest, your lordship.
He in fact
But
submitted that.
no, lordships.
They
As per ground of arrest, there is no any whisper that he will be arrested. But no any mention. 5 accused person being arrested as per FIR, your lordships. Petition number 2, no reflected any name. But on the day of incident, he was busy in business in
No,
Gauhati.
For 1, he already fled away.
He is being a driver of the said vehicle.
No,
But
why he fled away?
fled away means there are 2 altercation between both of them. They demanded money for carrying those cattle, the VDB body and other associate members. That is why he fled away. But other part, there are 5 accused person is arrested. In the meantime, I will cooperate the trial investigation agency, your lordship. Any condition may be imposed. I will
Mr.
cooperate.
S. Islam.
Yes, Islam.
Mr. S. Islam, report. Report. Return additional PP everyone. Submitted by Mr. Is that it is to petition. However, the fact that the one car was driven by this petition number 1, and when the deputy second party demanded him money, he could not offer any money, and during the interrogation, police came and he fled away from the place of incident. But he is to be connected in the arrest. Also, the petition number is not at all in the arrest, and his name is also mentioned in the arrest. However, he is searching by police as he is related to accused number 4 and 5. In that context, only the police personnel is searching for it. However, to be further submitted, the all the 3 weapons in question are already been recovered by police, and there is enhanced custody interrogation of the police present petitioners may not be necessary for the purpose of investigation. However, they are ready and willing to extend their cooperation in the further investigation of this case if they are granted with privilege of interim arrest. Mr. What done an additional PP submitted in this. That these two petitioners are also involved, may involved in the alleged offense. And from recording report of the other co-accused persons also, it is seen that this is an organized crime, and the 5 accused persons as well as the present petitioners also may be involved in the similar kind of offense. Mr. Watford accordingly insisted to call for a case. Interim. Okay, you'll be under interim.
I'll go back. I'll oblige.
On my lord, 9th of April.
9, no,
or-
9, stop giving 9.
Then on 21st of April. my lord.
Oblige, oblige.
May I please allege? 482 application. Here in this case, the petitioner, 3 of petitioners filed their PRS bail in connection with the Howli PS case number 17/26. Before I go into this FIR, Lordship, the petitioner number is the husband of the informant, petitioner number 2 is the mother-in-law, and petitioner number 3 is the brother-in-law. Here in this case, one Nazima Begum, the informant, lodged an affair on 13th February 2026, lodged before the Howli PS and stated that all the accused person are physically and mentally tortured to the complainant, demanded dowry case of rupees 3 lakhs, and the accused number 3, Mizazul Haq, trying to rape in her absence of her husband, and 4/11/2025, the accused person physically assaulted the complaint. The affair, kindly come to the page number, started from 17 is the Thai translate copy, page number 18. Mary. This case complainant is that above them accused number 1, 2, and 3 are husband, mother-in-law, and brother-in-law of the complainant, respectively. On 19/4/2019, complainant got married with the accused number 1 by dint of Islamic ritual. After such marriage, the accused person demanded dowry from the complainant, and they started torturing her physically and mentally. The complainant resumed her conjugal life for the sake of saving the same in her husband's house. As a result of their conjugal life, a male child was born on 7/5/20, and he was named Aram Alam. At her marriage time, her parents' house gave her all freedom and one case 1 lakh, and in 2020, it's very important. They had given 2 lakhs from her parents' house again. But after the birth of the said child, they had again demanded rupees of 3 lakhs from the parents' house, and they had started torture her again physically and mentally. And this time they had demanded a Maruti car and torture her too much. The accused person have threatened directly that unless the demand of rupees 3 lakhs and the Maruti car is given to them, she will be driven out therefrom. The accused number 1 has been torturing her by asking for the various dowry with the direct help of the accused number 2 and 3. In absence of their family members at home, the accused number 3 took the opportunity. He tried to some occasion to commit rape on the complainant by tearing her warm garments. The complainant has informed the matter to the accused number 2, but she directed the accused number 1 to continue torturing her, and she was kept. Next page, page number 19. Empty stomach, they are frank and physical assaulted, but she tolerate all such torture for the sake of saving their conjugal life and for the child. But on 4/11/2025, the accused person jointly demanded her rupees 3 lakhs and the Maruti car, and they have threatened that if she returns without the demanded dowry and the car, she will be driven out from their house. And if she retreats, she will be killed. Complainant under compulsion had to take shelter at the house of their parents to save her life, and still she is being at her parent house. Regarding the matter, she went to the police station for lodging the case, but police did not take the affair, and hence she is filed the case for justice before the court, lately under compulsion. Presently, the accused person number 1 again threatened her of life, hurling abscons, sanks language, and it was also threatened that the complainant and her family members by hit by the vehicle. These are the allegations. And as per the allegation, police, the Howli police registered the case 17/6 under section 85, 64, 62, 1153, subclause 5. All the allegations are totally baseless. Why all the sections are not tracted? Kindly, my lord, come to the page number 7 in my petition. Page number 7, para number 9. Got it, my lord. Page number 7, para number 9 clearly stated that the informant is not ready to stay with her family. They are not
Okay,
believing in
this
a
is your
joint.
case. This
Yes.
is your case.
Yes.
Yes, what?
So,
Otherwise,
so-
from the contents of the FIR, it seems that initially 1 lakh, 2 lakh, and thereafter 3 lakhs and multiple. So these are the allegations.
my lord, why
CD may come.
the accused number 2 is a totally innocent because she is a lady of 57 years. Now she is doing a service. After 3 years, she is going to be retired from her service. She is an assistant teacher. Now school is open and police lots of time they visited the house and the school. He may be any time point of apprehended. So my prayer before is kindly protect me till they come from the CD, my lord.
You 3 petitions will be under interim protection.
Yes, ma'am. Master. Highly obliged.
21 per.
Please, your lordship. May I please, your lordship, pre-arrest bail, lordship, the dispute between two brothers' family, lordship, own family, regarding a plot of land which was mutated by the husband of the informant, lordship. And when it was caught, the FIR has been lost, lordship. Will kindly see page 10, the FIR, lordship. Lordship, 6 person has been named, lordship. The 1 and 2 and 4 and 5 are the husband and wife, lordship. Most respectfully, it is submitted on 9/2/2026 at about 6 p.m. in the evening on instruction of the accused number 6, the accused number 1, along with 2 to 5, all the person, lordship, name, in a pre-planned manner and in a conspiracy illegally trespassed in the house of the informant. And the accused number 1 forcefully grabbed the informant from behind and against her with his in the cheek and excused her, lordship, when the informant tried to obstruct the 2 and 3 toward the one owned by the informant and outraged her modesty. The second one kicked in the belly of the informant, flew on the floor, and accused number 1 and sat on the chest and pressed the neck to kill. The accused number 2 forcefully the hands in the private of the informant. Due to the attack of the accused person, the informant sustained injury in the defined part of her body, and later on the neighbors came to a place where saved the informant and proposal of compromise was going on, where the delay there. Now, lordship, one thing, the allegation which was brought in the FIR, lordship, can it be possible when their respective wives are with them, lordship? The allegation, lordship, because lordship will kindly see the accused name, lordship, the 1 and 2, 1 and 2, lordship, and 4 and 5 are the husband and wife, lordship. When wives, respective wives are there, lordship, can this allegation can be then be done, lordship? Other beating and all, lordship, that can be acceptable, lordship. The allegation which against the outrage has given, can it be possible, lordship? It's only because that I have categorically stated in paragraph 6, lordship, of the 5 of the petition. It is due to a lordship, their property, lordship, which the husband of the informant has wrongfully, lordship, mutated the entire property in his name, lordship. And because of that, lordship, to restrain us, this FIR has been lost. If wives were not present there, lordship, then it would have been possible, lordship. And in relation, lordship, the informant is the auntie of accused number 1 and 2, lordship. This is my humble submission, lordship. That till the CD come, lordship, lordship, protect them, lordship. Because the allegation, lordship, is nowhere can be accepted, lordship. When wives are there, lordship, and the informant herself says all have come pre-planned, lordship. And presence of their wife, lordship, that lordship is hard to believe, lordship, such kinds of allegation. And whereas in relation, the informant is the auntie of 1 and 2, lordship. She is the auntie because the accused number 6 is the brother of informant husband, lordship, own brother. So in that relation, lordship, and the 1 and 2 are the son of accused number 6, who have already been arrested, lordship. He's a 60-year-old man. He is already been arrested.
Who arrested?
That father, lordship, accused number 6. That
got
forwarding I have annexed in the petition lodge. We have already arrested the father. Informant is the accused number 6, brother's wife lordship informant. Their own relatives lordship, all are within the family because of the mutation part lordship. So only to restrain us, this FIR has been given. When we protested that why you have mutated all the land in your name without informing us, that is the reason this FIR has been.
Prima facie, my lord, it seems that she has made lots of allegations, but in the last line, my lord, Apusor Prostab di Apus Nuhat Ajarat dia Pula. So, my lord, initially, my lord, made lots of serious allegations. At last, my lord, only because my lord, compromise was not made, she has lost this.
Not in the delay part, lordship, only that part, lordship, to believe, lordship, whether it is possible before the wives or not. That is the. Let the case there come with it.
Has made it not the- but we were- Land dispute between the parties. And the husband of the informant had fraudulently mutated the entire property, which is the way which where the accused person is supposed to be. To that context, there was a quarrel between the parties, and in that context, the FIR was lodged with some concept of allegations. However, the compromise was also going on this parties. Mr. Nirpada submitted that in presence of the wives of the accused number one and one and one and 4 and 5 are the wives of whom?
1 and 2, lordship. Lordship will kindly see the FIR names reflect, lordship. One wife is 4 and 2's wife is 5, lordship. Serial.
Civil to commit such kind of offense of outraging modesty
And 3 is their mother.
in the informant in presence by accused number 1 and 2 in presence of their wives, that is accused number 4 and however, the petitioners are ready and willing to extend their cooperation if some kind of information. Mr. Board, objection sufficient allegation brought against the petitioner and accordingly system call for against. Considering the statement made in the submissions made by this court is offering some interim protection may be petitions. Okay, you will be under interim protection.
Got
Again, it will be
On 22 format.
22.
22.
22.
Much obliged, your lordship. Much obliged. Much.
Anticipated bail application does it petitioner is a government employee. But he is not a FIR person. But one notice received from the investigation officer, page 18, under section 35, indicate 3 of BNS.
He already received the notice.
Notice. You want to appear before IO is not FIR or government employee. Allegation against the other person, informant said that once the Panjol Hazarika collected 11,50,000 money from her for giving a job to her daughter. That money is not returned or job also not given. Therefore, close this FIR.
Job was to supposed to give in your department.
No,
You are from which department?
health department.
Health.
I'm a ward boy. Hospital, model hospital, ward boy.
Then why you are apprehending arrest or why 35(3) was against you also?
Don't know, why notice is set for me.
Where is the FIR?
FIR page 7.
It seems that the accused Pranjal Hajurika
Lordship, he is the main accused.
disclosed his identity as a driver of Ranjit Kumar Das.
Sir, wife driver.
Huh? Oh, wife's driver.
Wife driver.
Acha.
He's arrested. I'm ready to cooperate with IO. I'm a government employee.
Where's your 35(3)? Try it.
Is 18.
Page 18.
Let him appear.
Yes.
From the FIR, I don't know why.
Maybe, my lord, yes, from the
You
FIR, my
are
lord,
for health department, and how you know it is Pranjal Hajurika?
Neighbor, maybe neighbor.
Otherwise, my lord,
Because
let him appear, my lord. Otherwise, my lord, it cannot be possible only for Pranjal Hazarika, my lord, to being a driver of that, my lord. He cannot do this type of offences, my lord. So, my lord, therefore, his grounds of arrest regarding to uncover a potential larger racket. Maybe some other persons also
Maybe.
involved because of that. Otherwise, let him appear. Let city come to everything.
And it is not stated in the FIR that in which department her husband will be accommodated.
Her daughter in hospital, my lord. Job for her daughter in hospital.
Hospital.
He would give a job to her daughter in hospital.
Oh, acha. That's why.
Forwarding report, page 14.
I may work for
Report put. Shall be a bit. This is the application. In the submitted time, that he had already received a notice section 25 PPNSS and is ready to cooperate in investigation of this case, give some interim protection. However, there is no allegation against the present petitioner, and he is no way connected in the case. Mr. Bond submitted in this may be given appear before the investigating officer in compliance of section 3, considering submission made by learned statement made in the FI and other aspects of this, and when it needs to extend the privilege of interim clearance bill. Okay, you'll be under interim. 22
21 4, my lord.
21
21 4. 23 4.
23.
May it please your lordship.
Yes.
Lordship, this is a pre-arrest bail application, lordship. I cannot say I'm very innocent. What has happened, my lord? During the time of Magh Bihu, I wanted to sell some rice. I collected those rice from the village, lordship, and I was supposed to sell them. But then the police has apprehended me, and lordship, the tractor by which I was carrying was given to the owner. During my petition, it was given to the owner. The rice was seized and it was given to the FCI. Now, my lord, under such conditions, lordship, I am only praying that my statements will be recorded, lordship, and I may be given a chance so that I can prove my case how I have collected. Because I have approached the district judge, lordship. They have given me interim protection, but there was no specific direction to appear before the police, and I think I didn't have appear before the police. And the district judge has rejected my bail application on the ground that I could not show how I have collected the rice. So, lordship, I at this
Just
stage,
how can you now say? Where is the rejection order?
Your lordship may kindly peruse page 19. my
Page
lord.
19.
Relevant portion, my lord.
It appears that 90 bags of rice were seized and the accused have no valid answer regarding possession of the rice bags. In view of such materials on record, the submission made by the council that the rice was collected for the household is not acceptable. And I'm considered view that the accused are not entitled to the pre-arrest bail application. So, lordship.
But earlier you were granted.
Yes, lord. Now, what
But in spite of granting in your interim period, you have not appeared.
I as per what I believe, I have not appeared, Lordship, because my instruction is that I didn't appear, Lordship. So, Lordship, if I may be allowed to appear at a very short date, Lordship.
90 bags of rice were recovered from the.
Yes, yes, 90 bags is.
90 bags. And my
Ah.
lord, at that point of time, he failed to provide any, my lord, reasonable explanation of from where, my lord, he,
No,
my lord.
Yes,
uh,
Lordship,
because of
I
that,
just,
my lord, those petition, my lord, after perusal of the case diary, his bail petition was rejected, although initially granted interim.
Lordship, bare perusal of the FI, I'm fairly submitting, Lordship, bare perusal of the rejection order, it is not, in the case diary, it is not revealed that the rice bag was stolen. What I'm given to believe is that during the time of Mark View and I'm not so innocent also, I'm saying so. I have collected some rice from the, I have to get some extra money. And I wanted to sell that. That is what I have been given made to believe. So, Lordship, with regard to those stolen bags, or it is not stolen, but whatever those rice bags are there, the explanation could be given by the police. It is not there in the during the time of in the district judge. So what I am praying, Lordship, I may be given a direction to appear before the IO, and if I am not able to produce anything, then the case will go accordingly. But at least let me submit before the IO within a period of 5 days, and Lordship may.
But obviously, you were granted an opportunity of interim protection.
Yes, Lord.
And the here from the rejection order, it seems that the
No,
order is
Lordship,
that it
I have-
appears that the 90 bags of rice were seized, and if the accused person have no valid answer. From
No,
where
Lordship,
he is saying
Now
this one.
also he is trying to say that those bags are, my lord, donated bags by the village.
Not donated. No, I have collected.
How
Let
can
me
that be
no
donated
let
bags?
that we cannot now say if
So just protocol, just I want to see. In one time, at one hand, it is saying that he was on interim protection,
Yes,
and interim protection, and thereafter the after perusal of the case there, that his interim protection was rejected or the bail
he
application.
has not also appeared before
But
that.
now Mr. Thacker is saying that probably he has not appeared before the IO. But where from this observation
Yes.
come?
No, my
that,
that observation I have not.
Yes, no, observation is that the persons have no valid answer.
Yes, yes. No,
Where from it is stated? Is definitely from the CD. Where then how? If suppose he is not appeared.
Probably he is instructed by his, my lord, client, but that was not also reflected in the order, my lord. Anyway, my lord, if he has not appeared after obtaining in that also, my lord, he violated the order of the learned trial court, my lord. Otherwise, also 90 bags of rice, my lord, not a, my lord, small quantity, huge quantity.
I am also not saying that I am very innocent, but my lord, at least I may be allowed to appeal, Lordship. I also don't, because
But how you have collected those rice bags?
as per my instructions, Lordship, it was Bihu time. Lordship, I wanted to make some extra time. So what I did, Lordship, I have collected from my villages. They wanted to say, okay, you go and sell it because now you'll get good because pizzas and everything they make it. So I have collected those rice and I was supposed to sell it, but I couldn't sell it. And the rice is already given to the FCI, and the tractor which I was using was given to the owner. So I am left with nothing, Lordship. Now everything, like the case itself has now nothing is there. The rice has been also given away. The tractor is also given to its owner. And Lordship, and one more thing, Lordship.
One more thing, Mr.
If my lord, those
303 is there, but whether
otherwise, my lord, he submitted that those rices were already handed over Jimma to the FCI. So definitely seal of the FCI is there. So those rices, my lord, FCI, my lord, PDS rice.
now it is handed.
Now it will be given to the
Yes.
At that time, he collected those rice.
Rice.
Now, after the recovery or after the that one seizure, those were given to the FCI. But 303 is there, but where from 303? It's not here. I don't know. The order doesn't say so specific.
CD will reveal the, my lord. Otherwise, his explanation in this petition is also that those are donated, my lord, by the villagers. That is also not an acceptable, my lord, explanation. Anyway, my lord, if you want
Donated
to...
means he collected.
Collected, Lordship.
Mr. P. Mr. P. brought up the done additional PPF on behalf of Secretary Select Mr. Teka, the done additional submitted in district that the present accused petitioner no way connected in the alleged offense. However, it is the fact that he collected some rice bags from the village persons to sell it on a higher rate to get some commissions. But during that, he was the rice was seized from its position and were seized, and those were handed over to FCI. FCI post. The truck and the tractor through which the rice bags were carried were already seized and handed over to the owner of the and handed over the Jimma to the owner of the tractor. Mr. Deka further submitted initially the additional session judge Bilasipara had granted him interim period. However, there was no such direction for appearing before the IO and appear before them, though he was ready to cooperate with the investigation. But after appraisal of the case diary, his bail prayer was rejected. First. He further submitted that till that he has no opportunity to appear before the IO and to make explanation as to how the rice bags were collected by him. Accordingly, Mr. Deka submitted that an opportunity may be given to the present petitioner to appear before the IO and to cooperate in investigation. Next, Mr. submitted that from the order passed by the learned session judge, it reveals that he could not give any valid or the proper explanation regarding the 90 bags of rice which were seized from the possession of the accused. Accordingly, Mr. Board insisted to call the next, considering the entire facts and circumstances of this case, all the and that one opportunity may be given to the present petitioner to appear before the IO and cooperate in the investigation of this case, and also to record his statement. In view of this, later interim protection be provided to the present petitioner during receipt of case diary. He is brought up when it can be.
22/4.
Within
Be
one,
under interim protection, appear before the IO within 7 days from the date.
Highly object.
May I please, Your Lordship? Lord, this is PRS bail application, Lord. Initially, FIR was lodged to the Gorsuk police station. Subsequently, it was transferred to the Maibong PS under Dima Hasao. Due to a place of occurrence fall under that jurisdiction of the Maibong police station, Lord. Page 20 is the FIR. Relevant part I'd like to read out, my lord. I would like to inform you that the complainant company booked materials under its consignment note for its various customers, which was to be transported from Pamohi Gorsuk, Gauhati, Assam to Aizawl, Mizoram. The complainant company approached Mr. Raj Bharve, proprietor of MS Sri Ganesha Transport, having his office at NH 37 Landlamati, Prakash Kanta, Beltola, Gauhati, so and so, to provide a vehicle to the complainant company. On dated 14/4/25, Mr. Raj Bharve provided a vehicle bearing registration number AH01 HC 6078, owned by Mr. Asmat Ali, present petitioners, petitioner Miller, son of so and so, village Kawatika, Bijni, subdivision Chirang, Assam, mobile number so and so, so and so. It has been stated that the final paid amount for the transportation had been settled between the complainant company and Mr. Raj Bharve for the amount of rupees 55,000. It is stated that out of 55,000, an advance payment of rupees 45 was paid to Mr. Raj Bharve. The balance payment 10,000 was to be paid at the destination point after delivering the goods on so and so proper condition by lorry hire salan number Imanima so and so dated so and so. The materials having value of rupees 74,14,000, 55,000. This figure is important for this case for me, my lord. 4,14,055.
were loaded into the aforementioned vehicle and entrusted to the broker Raj Barbe, the vehicle owner cum driver. The vehicle owner cum driver, that is present petitioner, Asmat Ali, for safe delivery at the destination point. The vehicle with the loaded materials was ready to be dispatched on 14/4/25 to its destination point. The vehicle was being driven by Mr. Asmat Ali. This is the relevant part of the FIR. My lord, now I want to peruse, my lord, page 48, RC of the vehicle, my lord.
Sheet also submitted.
Yes, under trial case, my lord. I forget to submit under trial.
Oh, it is under trial.
Under trial. yes,
Sheet submitted.
my lord. Now, in the why I am perusing, my lord, RC, here is mentioned a date of registration of vehicle 29 November 2024. Owner name Asmat Ali, who is a present petitioner mentioned here. Now, my lord, for a moment, kindly see the paragraph 6 of my petition, my lord. That the petitioner begs to state that he is the owner of the vehicle number, registration number 01HC6078, model number 1916, chassis number so and so, engine number so and so. On 14/4/25, he has loaded goods in the said vehicle from Sri Ganesh Transport, Gauhati, and started his journey from Gauhati to Aizawl. During his said journey, burst 4 tires of the vehicle, one after another.
Whatever, you are shown as an absconder.
Absconder, my lord.
Why?
My lord?
You have not received anything?
No, my lord. Moreover, this punishment is maximum 7 years. 35 BNSS notice also not served upon.
Whatever.
Yes, absconder. Now, my lord, as such, at that time, he.
No, it's a long period, para. No need to read all this para. What is the gist of the case? What do you?
My lord, what I want to submit, in short, I am
He is
submitting.
the petitioner is the driver of the vehicle, and the allegation is that they fabricated one accident and thereafter sold all the article materials of the truck
Yes.
to someone. So this is the allegation.
That is the
against
allegation.
driver. So since then, he has also not cooperated during the investigation, and charge also framed. He has not appeared before the trial.
Charge is already framed.
Charge already.
Now NBW is issued against him.
No,
or
no,
what?
only someone, my lord.
Someone.
Only someone.
Why case was split up or what?
Fixed for, my
In
lord.
his absence, how?
For fixed on 2/2/26 for appearance and copy, my lord.
Appearance and copy.
Thereafter, my lord, it is not.
Still at the stage of appearance. Then.
Yes, appearance.
Next date is, can you tell us the next date?
22 mentioned that.
46 of the 2/2/26.
2/2/26 has already
After
gone.
that, in the last date was 10th of March. Last date
10th
was
of March.
10th of March, and next date I'm not.
So now pending before this
SDGM Dimahasa, my lord.
Dimahas.
My lord. Now, in short, I'd like to submit a few points in support of my case, my lord.
No, we are calling for the case record. That's why
Well, before.
that's why I'm just asking you which is your next date.
Yes, my lord.
Before next date, I want to fix the date. That's why. If it is on 10th March, then obviously 10 March is already gone. So it may be either I don't know what is the connected date.
What I'm trying to submit for a moment, if your lordship permits me, my lord. Actually, I am the registered owner of this vehicle.
It's okay, you are the registered.
Now, during my journey, my vehicle was faced with accident like 4 numbers of tires of my tracks, 6-wheeler tracks, my track, my lord, burst. And that is one after another. And after that, I have no money to repair or purchase the said tires to continue with my travel. Then I have contacted with my travel agency, that is co-accused Raj Barbe, and asked him to pay some money to repair or purchase my tire in order to reach that destination. Then, my lord, he refused to give my money. Then I have informed to him and sent my live location, GPS location to him, and parked my vehicle in front of a dhaba nearby some shops also there. Then I have come back from there to home to manage money. Then distance from my house to place of occurrence almost 500 kilometers. So it was not possible for me to arrive again the place of occurrence immediately. 2-3 days was already gone in between that. Then, my lord, after I have informed from my travel agency, Raj Barbe, co-accused of this case, your vehicle not found in the where you have sent my location, location to me. And subsequently, I have informed by him my vehicle was found 300 foot below from the road, accident condition. And till date, my vehicle laying on that place of occurrence and fully damaged. Now, my lord, my vehicles, brand new vehicles, registration year 2024, 6-wheel tracks, my lord, almost value it is more than 30 lakhs.
On merit of the case now and
More than 30 lakhs. And allegation against me 17
It
lakhs.
is already charged case, entire merit, how
Hello.
can we consider?
So logically, allegation actually allegation against me illogical because my vehicle worth amount
Okay,
30.
yes, water when it can be fixed. I don't, he is not.
And already investigation over charge sheet submitted. I will appear and continue with the trial, my lord. Some protection, my lord. And in my petition,
First or second? 2nd April?
yes, 2nd April, my lord.
We'll see this, the thing
PCR,
why you
lord.
have shown as an absconder, and we just want to see.
And the charge sheet, one thing I would like to submit.
You are saying only with summons, isn't it?
Yes,
So
summons.
if date comes in between, then you pray for another date through your counsel. We'll see to it.
My lord, from there. Now, in the charge sheet, surprisingly, co-accused Rajbarbe discharged from the charge sheet by the police. And learned trial court taken charges against him by stating that yes, police submitted charge sheet wrongly because in the FIR and subsequent other materials.
Some observation by the court.
My lord. Court suo motu proceeded against the co-accused, but in the charge sheet, police co-accused not sent for trial.
Rajbarbe is one of the accused or he is not the accused?
In the charge sheet, police shows the
He was
co-accused
not
not
an
sent for trial, but court suo motu taken cognizance against him also.
Okay, we're listing it on 2-4.
My lord, I'm obliged, ma'am.
PCR, scan copy of the PCR and see. Register with 2-4. We want to fix it before your next day, but you are not in a position to say.
2-4 is probably before next date, my lord. I'm sure. 2-4 is probably before next date. I'm obliged, my lord.
You were on 22?
Maybe, sir, 22.
Yes, what is the position of 22?
It is not there. 22, my lord, search sheet submitted in this case. Petitioner is in interim.
You were on interim?
Yes.
So, okay, then we'll extend your interim for 15 days. You
Yes,
appear before the learned trial court will with an appropriate application copy, which may be considered. What is the CS number?
CS number 15/26, dated 21/1/26.
Okay, we're extending it. 15. The position of 24.
Earlier also, my lord, no one appeared on behalf of the, my lord,
Oh,
petitioner, my lord, but
yes.
I had received.
On 19/2, interim order was granted, I think.
Yes, ma'am. And
Oh,
from
no,
the-
interim was not, earlier it was granted, no?
Yes. And recently I have received a detailed report from the IO on 9/3/26, my lord. Matter was earlier listed on that day, also no one appeared on behalf of the petitioner, my lord.
Yes.
You are lucky.
And he cooperated or he is not?
No, my lord, he has, my lord, from the report dated 9/3/26 till 9/3, my lord, he has not appeared. My lord. Two
not-
petitioners, my lord.
Two petitioners.
Two petitioners. No, after some time, if my lord, anyway, if they appear.
Can be. Wait. 24 is still not built.
So they,
Ah,
right now
ah.
also they have not appeared, earlier also not appeared. So
Maybe.
my prayer before Lordship
Just
in
we
team
thought
have
that
granted
for
only
time
maybe
being we kept it.
next maybe better.
No one appears to call for the petition. By Mr. P. Potter, Learned Additional PP applicant state. Is submitted to the CD is already received. And CD is lying before this court since last day. Order is submitted that as per report of the IO dated 9/3/2023, after order obtaining the order of interim pay as well, the petitioners did not appear before the IO nor cooperated in the investigation. From the record, it is seen that the that on the that on 19/2/2026 also the case diary was received, but on that occasion also it is seen that the statements of the petitioners were not definite, for which the updated case diary was called for. But from the report dated 9/3/2023 by the IO, there is that the petitioners did not cooperate with the investigation. In view of this, of this petition, the the interceptory bail application is hereby disposed of, and order of interim petitioner dated 23/10/2025 is hereby vacated. CDB is disposed of.
May I plead your lordship?
Yes.
As per order dated 16/12/2025, I am on interim bail and I have appeared before the investigation officer.
Yes, what?
Here I have received a case diary minor. After interim, he has appeared and statement was also recorded minor. But regarding his involvement minor, he is the main person minor who sold the vehicle to the minor one Babul Ali minor, from whom it was recovered minor. He is the person minor. What happened minor? Here one truck was minor taken away with a tractor with a from a Nogao minor with the help of a crane minor crane. And from the driver of the crane mallet, it was recovered from the mallet in the district of Dorong mallet. And that in the meantime, mallet, the present petitioner has sold the mallet vehicle at rupees 2,30,000.
His name is Adil Haq.
Adil Haq mallet. He is the main person behind it.
May I plead your lordship?
Yes.
Paragraph 3 of my petition, that is page number 4. I have categorically stated I was a middleman because scrap dealer will not buy from me until and unless he is met with the owner. I have already accepted that 10,000 has been given to me as a brokerage. Scrap dealer was arrested on that very day. That particular driver and owner of the crane was arrested on that very day. Nobody can sell a vehicle which is under the custody of police station. So how can I sell it? I am not the owner.
You
So,
are
page
not the
number,
owner. That is the crux of the case.
yes, and
You are
most
not the owner.
yes, most importantly, if we go through the
Here
FIR,
he has admitted in his statement that he sold it one to Babul Ali. But later on, Babul Deka, later on he said that he sold the vehicle to Babul Deka. And,
yes, I have showed that. Not,
and
I
he
cannot sell it,
purchased
no.
the vehicle from one Wahidur Rahman Ahmed.
That is his statement, ma'am.
That is
His statement, ma'am. That is
co-accused says so. Then obviously co-accused will say that, and he also admitted that he sold it.
Malan, he was with the all of them were there, Malan, when it was taken from Nagaon to the Malan, the Dorong district. From the statement of the Malan, co-accused Malan.
Yes, yes.
He was also there, Malan, along with
He
him.
was there. He was along with Bubul Deka.
Fine.
He was there.
Then-
No dispute about it.
Fine.
Now, he is saying that he was with Bubul Deka and he drive the train
Fine.
by Bubul Deka and it was sold to him to 2,30,000.
Fine.
That is admitted. But subsequently, he said that he purchased the vehicle from one Wahidur Rahman Ahmed and from Khanapur. And then only he sold it.
Fine.
That is his.
That is his statement.
Now, what do you say? This custody interrogation will be required?
Malan,
Yes.
yeah, IO, as per IO, Malan, IO has paid for Malan, his custodial intervention. As per IO, that is his sum.
Your Lordship, I beg to submit one thing. FIR is very clear. FIR is very clear, number one. And their scrap dealer, I recognized scrap dealer, they cannot buy any sort of vehicle from me.
You are recognized cab dealer.
No, I'm the middleman, I'm a driver.
Who is this cab dealer?
Scrap dealer is also already arrested and got bail. I'm not. I was not the owner of the owner and driver of the crane also. I am a person who see all these scrap vehicle and contact the scrap dealer and I take a money and I have accepted and it is very much there in the CD also that I have taken 10,000 rupees via mobile transfer. Now the question is, scrap dealer is a recognized scrap dealer. Can a scrap dealer purchase any vehicle from me? I'm not the owner. The matter is that if we go through the FIR, it is very clear.
Okay, hard your Mr.
Are they?
Hard Mr. Are they return it consultation? It's P. Sharma, they learn a PP, a payment an application, so it's is submitted by Mr. Day that they present a petitioner against. And however, it is the fact that purchased the vehicle from one scrap dealer and on good faith, and was sold to one Deca, for which he only got the commission of rupees 10, which is also credited to his account. That apart, he is not involved in the dealer. And he further submitted that he cannot sell a car to a no. However, after obtaining the order of interim pre-arrest, dated 16/12/2025, he appeared before the IO, cooperated with the investigation, and his statement is also recorded.
Right.
He is still ready and willing to extend his cooperation in the further investigation of this case. He is granted with the privilege of pre-arrest. Mr. Sharma, the Gauhati Division PP submitted in this regard that only available material of the case diary saying that he is the main culprit of this case who sold the stolen vehicle to one the co-accused at rupees 2,00,000 from the vehicle was recovered. But he submitted that there are the IO has given note where from it is seen that his further custodial interrogation may be necessary. Are not some more tax cases. Mr. Sharma accordingly reduced conviction in allowing him to release on pre-arrest, to allow him to go on pre-arrest. Next point, they are hearing the submission. And it is the fact that the vehicle has already been recovered from one of the co-accused, Bobul Deka. But considering the other methods, the case diary, the conduct of it and the results of the investigation vis-a-vis the recovery of the vehicle. Find that security interrogation may not be necessary for interest of in view of the in or interim interim bail granted to the present petitioner dated 16/12/2025 is hereby made absolute with same terms.
Obliged, Your Lordship.
My lord, in item 26 CD notice, my lord, they are in interim, my lord. After that CD was called for.
City not received, issue repented. Call for the updated one. Please see matter according when it can be.
My lord, April 7th, my lord. 7th. No, after maybe.
7th
Or after Bihu, man.
Bihu date.
After Bihu. 22nd, man.
2nd of April, interim be continued.
Object.
27.
Here we have received the complaint. It was retained, na? It was retained, I think.
CD written, my lord. In the earlier CD.
Well, here the dispute is between the neighborhood, my lord, neighborhood disputes. And the allegations, my lord, is page number 15 onwards, my lord. The allegations, my lord, that the act has been done in the death ceremony of a public gathering, my lord. And that act is not possible to do in the public gathering, my lord, at all. His statement is that, my lord, the Kamal Das reached the ceremony and without having any reason to, he started to use the slang language when I opposed to the said accused physically assaulted me. But in a public gathering of a death ceremony, public assault to a woman is not at all possible. This all affair is the exaggerated version of the act. Yeah, my submission, my lord, in this incident, my lord, the custodial interrogation is not required, my lord. You see, my lord, the acts, it's in a public gathering.
এখন দিন। And there are some eyewitnesses, my lord. Their first statement of herself is there, my lord. And injury report is also. Lordship, kindly period.
So what is your submission?
My submission is that, my lord, all the eyewitnesses implicated the accused present petitioner, my lord, and that they have done to a vehicle, my lord, hit the vehicle, and thereafter they tried to kill her, my lord. That is their allegation in the, my lord. Lordship, kindly period, my lord.
That is only allegation.
Eyewitness.
Hitting through the car and killing intention is, my lord, something different.
Injury report also reveals.
But in this juncture, whether introduction custody is required or not, that is the also question. And that is, my lord, the dispute between the neighbors, previous dispute is also, that is the genesis of the case. Initially, there is a dispute, man.
Her statement, though. and his conduct, my lord, regarding a lady, my lord, in the occasion of my Shraddha, my lord, what he has done, my lord, and thereafter also try to hit to my lord, vehicle, my lord, and injury report also, lordship, may kindly tell. That is
In question is that there may be some altercation, some assault may be there.
Fine.
Subsequently, he tried to hit with the vehicle and hit it.
Fine.
And thereafter, again, he pushed
My lord,
back
push
the
back the
vehicle,
vehicle, my lord.
and then again hit. Second time it was.
That is
Not intentional. Not intentional, my lord. I have asked my client also. That is not intentional.
His not intention.
No, my lord, that is, my lord, because both the parties reside in the same boundary, my lord. Earlier also did some dispute, my lord. But this is a hit movement, but that is.
Agree that is the being a neighbor, there may be some issue, there may be some quarrel. The conduct, you see, first of all, he went there may be some quarrel. Definitely out of anger, he may hit also. That is that part is also okay. But subsequently, see his conduct with the vehicle, he tried to hit. Once he hit, she fell down. Again, he came, backward, moved back the vehicle, and then again second time. If that is not acceptable.
I have asked.
Okay.
I have asked my client, but he said it's not. He has not done this.
Okay. You are Mr. H.
B. Sharma.
B. Sharma. Part Mr. B. Sharma. Done it also. Also part Mr. O. B. Sharma. It's submitted by Mr. Sharma that from the contents of the FI itself, it is seen that it is seen that is such kind of incident is very improbable in a public gathering where admittedly victim as well as the accused persons visited here to attend a Shraddha ceremony. However, it is the fact that there was a quarrel between the parties due to some issues, earlier a previous grudge and being the neighbor. No, the quarrel between the parties who were the neighbors due to some previous grudge. That apart, there is no such incident took place as alleged. However, the petitioners are ready and willing to extend his cooperation in the further investigation of this case if he is granted with some interpretation. Mr. Das Sorma declared additional PP submitted in this regard. There are sufficient incriminating materials brought against the present petition, and from the statement made by the witnesses as well as the complainant, and from the injury report itself, it is seen that due to such act of the present petitioner, she sustained previous injuries on the person. His further stated that it is not the case that he hit or assaulted the victim the place of occurrence, but he tried to hit her twice by his car when she went out from the said ceremony. Accordingly, he submitted considering the conduct of the nature of offense. He may not be granted with the privilege of the
And the medical report also gives.
next para hearing this submission made by the is that, and there's the fact that there was a quarrel between the parties wherein the accused, allegedly the accused petitioner also assaulted the victim, but his subsequent conduct by which he tried to by subsequent conduct by which he hit the victim informant causing grievous injury in his person does not deserve a privilege of free respect. Accordingly, the prayer for free respect is hereby accepted. Your petition stands with
I pay for the reformative punishment if on condition basis.
Okay.
Yeah, please, Lord. Lordship, rearrest bail applications, Lordship. FIR is 14, Lordship. Harnicola maybe 10, Lord. Is 14.
Page 14.
14, 1 4.
Yes.
সম্মানপূর্বক বিনীত নিবেদন এই যে মোর হরু ভনী আমেনা খাতুন এজ 27 ইয়ার্স সন ডটার অফ সোয়েন্স ভিলেজ সোয়েন্স পাগল ভালদৰে কথা বুজি নাপায় লৰ্ডশ্বিপ দিছ টু লাইনছ ইজ ভেৰি ইম্পৰ্টেণ্ট পাগল ভালদৰে কথা বুজি নাপায় তাইৰ পাগলৰ চিকিৎসা কৰি আছো যোৱা ইমান তাৰিখে মোৰ খুৰা ল'ৰা কোচবিহাৰত মৃত্যু হয় ৰাতিলৈ ঘৰত লৈ আহে পিছদিনা যোৱা ইমান তাৰিখে ৰাতিপুৱা মোৰ সৰু ভনীক ঘৰত থৈ আমাৰ ঘৰৰ মানুহে খুৰাৰ ঘৰত যাওঁ মোৰ মা মোৰ খুৰাৰ ঘৰৰ পৰা ৰাতিপুৱা 11টামান বজাত ঘৰত ঘূৰি আহি দেখে যে মোৰ ভনী তলত উল্লেখ কৰা পদকীয়াৰ ঘৰৰ পৰা ওলাই আহি আছে পিছত মোৰ মায়ে মোৰ ভনীক সোধ-পোছ কৰাত হাতত দুটামান চকলেট পায় আৰু কয় যে পদকীয়াজনে চকলেট দি মোৰ লগত বেয়া কাম কৰিছে পিছত মোৰ মায়ে মোক কয় যে তোমাৰ সৰু ভনী পদকীয়াজনে ধৰ্ষণ কৰিছে দিছ ইজ দ্য এলিগেশ্যনছ লৰ্ড The first 3 lines, Lordship, it is clearly stated that she is mad, mentally retarded, could not speak properly, Lordship. Thereafter, these allegations brought. And the time of occurrence, Lordship, kindly see, at 11 p.m. a.m., Lordship. I am a married person, Lordship, having children, wife, Lordship, and adjacent family also there, Lordship. And this occurrence cannot be executed, Lordship, without attracting the attention of any others. He neither raised hue and cry, Lordship. When her mother asked, she made this statement, Lordship. And my instruction is that, Lordship, after filing this FIR, she has been influenced by her family members to record statement against me, Lordship. At this system, my prayer is that, Lordship, my case may be considered on the basis of medical report, Lordship. If medical report against me, Lordship, then I have no case.
Yeah, so Lordship, kindly page 180 statement, my lord. If she is influenced by the my lord in 164, my lord, 180 statement was given just after the incident, my lord. Lordship, kindly page 180 statement.
Medical report is not here.
Medical report is there, my lord, but final opinion, FSL it was sent, my lord.
At this stage, my custodial interaction may not be required, Lordship, considering the above fact and circumstances, Lord. And her statement may not be relied upon, Lord, considering the nature of the case, Lord.
Medical report I am finding where it's true prescription is there.
No, my lord. I have checked, but
Oh, acha, acha.
check, ma'am.
The occurrence shown to have occurred, Lordship, in my house, Lord, not any other place.
By other, whole tear was there.
Mine.
A tear was there in
Mine.
the hand.
Fine, that is.
But today she is a mentally retarded child. Not child, she is a major actually, but
Major
behaved
27
like a
years.
child because of her mental retardation. Should not do all these things with a
Mine.
such kind of girl who is not mentally sound. And her statement, not only before the magistrate,
Mine.
but even before the doctor also, same statement is there. So somehow she explained. She is not mentally so fit, but can describe what happened. Somehow, which is acknowledged. That is recorded by the
Mine in the declaration.
the learned
Yeah.
magistrate also, that has been.
Declaration.
Otherwise, see, there are many rape cases wherein they are consenting party and all. You know, we generally give a bail or these cases. Here, see the girl, condition of the girl. She is mentally retarded. Hard Mr. A.P. Sarkar, the Learned Counsel for the petition. You may have a child, you may have a married man, but what to do? Maybe you may be a dangerous man in that way.
Because
Marriage, status of marriage is cannot.
Not a consideration.
Lordship, I am pointing one point, Lordship, the occurrence took place at 11 p.m. and shown to have occurred in my house. My house is consisting of other family members.
Who's probably one person died, no? So most
All of them
got there. Go there to give.
Lordship,
this
the
city
persons
that,
died, Lordship, belong to,
Mati Dibolo, that means
Lordship,
the
belong to informant's family, not my family.
No,
Person
yeah,
died,
as a
Lordship,
neighbor, you
belong to.
never go. As a neighbor, you never go.
Lordship, yes, Lordship, but
In our custom,
but
to go,
ladies
when
already
many
remains,
people
Lordship, in home,
with
Lordship.
the dead body, even Muslims, even Christians, all go. Cannot say your neighboring person died. So how can you say that no one will go from your family? Cannot say, na? Hard Mr. A.T. Sarkar, Counsel for Deputy. So hard Mr. D. Sharma, the learned traditional people, this is an application and so and so in connection so and so CD receipt whereas receipt. Next, submitted by Mr. Sarkar that the present petitioner He is not connected with, he is no way involved in the LS from the FI. From the FI itself, it is seen that she was a mentally retarded girl, and the entire incident took place at about 11 a.m. in the house of the president's petition, which is practically not possible for a man to commit such kind of offense in presence of his other family members. The concocted FIR has been lost only due to personal and personal grudge. He further submitted that accused petitioner is a married man and having children, and he is always ready and willing to extend his cooperation in the further investigation of this case. He is granted with the privilege of pre-arrest. Next one, Mr. Sharma, the additional raised objection and submitted that from the statement made by the witnesses as well as the complainant recorded under section 180 and 183 PNSS, it is seen that the sufficient incriminating materials brought against the present petitioner who committed rape with a mentally retarded girl who could not understand what is happening with her. From the medical report, also it is seen that they have found rupture of the hymen. So the final final report is still awaited from the Mr. Sharma, according to the rules of submitted that custody interrogation may be required in this case, and hence it may not be a fit case to extend the privilege of pre-arrest bail to the petition. Next one, hearing the submission made by Learned Counsel. I have also paid his record, case diary. It is seen that there are sufficient incriminating materials against the present accused petition who committed, who alleged to have committed rape on a mentally retarded girl, and from her statement made before the learned magistrate as well as before police also found to be consistent, wherein she somehow expressed as to what had happened with her and by whom it had caused. Considering the aspect of this aspect of the case, and also considering the fact that a rape of allegation of rape is brought against the accused person for a girl who is not mentally sound. Considering these aspects of the case, do not find it a fit case to extend the privilege of pre-arrest bail present petitioner at this stage. Hence, the same stands rejected. Your petition stands rejected.
Obliged, Lord.
29.
Appeal, Your Lordship. Mostly as per order dated 18/2, Lordship, I have appeared before the IO, Lordship, and accorded my statement, Lordship.
We are on interim.
My lord.
Yes, Lordship, I am on.
After interim, he has appeared statement recorded, my lord. And regarding my involvement, my lord, there are several allegations against him, my lord. In the FIR itself reveals that, my lord, there is a promise to marry, my lord. Therefore committed, my lord, sexual assault for several days, my lord. Thereafter, some medicines were given for the abortion, my lord. That allegations are there, my lord, in the FIR, my lord. And there are some, my lord, WhatsApp messages are also there, my lord. But kindly please our statement.
for it, yes.
Lordship, if I may, Lordship, the FIR is based on the complaint of the complainant, Lordship. Complaint is 1 of 2026, Lordship. In the complaint, Lordship, she has accepted it was at starting, it was a consensual relationship, Lordship. They had a relationship from 2023. And subsequently, as per her allegations, Lordship, she got pregnant in 2024. Thereafter, as per her allegation, Lordship, the petitioner, he sent tablets to her via courier. And then she blackmailed him over the phone, blackmailed her over the phone, Lordship, to take the tablets. And Lordship, also as per her allegations, I mean her complaint, Lordship, from July 2024, they have had no contact. As per her complaint, I am going, Lordship. Only when she learned that he had married in November 2025, she filed a complaint in January 2026, Lordship, complaint petition, Lordship. So, Lordship, it is actually not a case of sexual, it is not a case of using deceitful means, Lordship. In the judgment that I had presented before your Lordship, the Apex Court has made a observation, Lordship. I want to read that, Lordship. It's on page 14, Lordship. It's in the judgment of the revision bench, Lordship.
Yes,
Yes. It is the case of Pramod Kumar Navratna versus State of Chhattisgarh and others, Lordship. Now, Lordship, here the court has observed, learned Apex Court, the bone of contention raised on behalf of the respondents is that the prosecutrix had given her consent for sexual relationship under the misconception of fact, as the accused had given a false promise to marry her and subsequently he did not marry, and therefore such consent was no consent in the eye of the law, and the case fell under the clause secondly of section 375 IPC. In this regard, it is pertinent to note that there is a difference between giving a false promise and committing breach of promise by accused. In case of false promise, the accused right from the beginning, would not have any intention to marry the prosecutrix and would have cheated or deceived the prosecutrix by giving a false promises to marry her, only with a view to satisfy his lust. Whereas in case of breach of promise, one cannot deny a possibility that the accused might have given a promise with all seriousness to marry her, and subsequently might have encountered certain circumstances unforeseen by him, or the circumstances beyond his control, which prevented him to fulfill his promise. So it would be folly to treat each breach of promise to marry as a false promise and to prosecute person for offense under section 376. As stated earlier, each case would depend upon its proved facts before the court. Lordship. So, Lordship, from the very beginning, there was no false promise to marry. It was a consensual relationship, Lordship. It's as per her complaint, Lordship. From the very beginning, there was no promise to marry, Lordship. It was subsequently they developed a relationship, then the promise of marriage came, Lordship, maybe as per her allegation. And Lordship, if for that matter, from 2024, after July 2024, there was no contact. If there was, she was so deceived, she could have gone before the authorities there and then. Why was she waiting for him to marry, Lordship? After nearly 1.5 years, she went to the police, filed a complaint, Lordship. It's not a case of false promise. It's a case of, Lordship, relationship going sour, growing acrimonious, Lordship. That is my case, Lordship.
Submitted by Mr. Das that the accused petition had already appeared before the in person to order of in person to the after obtaining the order of imperial space dated 18/02/2026 and cooperated in he is not ready to willing to accept cooperation with the party case if it is granted with the absolutely. Expert does for the subject that to be ingredients made in the public petition itself. Say that the petitioner and the victim had a consensual relationship from the very beginning, and allegation also he sent some tablets to abort their pregnancy through courier, which is not accepted. But I've seen that they had no relationship since July 2020. Only after the marriage of the first petitioner, on November 2020, she lost the false case with some concocted allegations. But he is ready and willing to direct his cooperation in further investigation. So Sharma Delane, the petitioner in the statement made under section 183 of the PRSS brought sufficient implementing metrics against the present petition. And wherein she alleged that he committed rape on the false promise of marriage. According to Mr. Sharma, raised objection and submitted that may not be a case to extend privilege to be arrested. However, he submitted that after obtaining the order of interim pre-arrestment, he appeared before the IO and cooperated in the investigation process. During the submission made by Nani Constable, considering the metrics available in the case diary and the already contributed, I find that custody interpretation may not be for the purpose of investigation. In view of this, the order of granted to the petitioner dated 15/2/2026 is hereby made absolute with safeguard.
My lord, here last two occasions, my lord, the public prosecutor was directed to take a report from the my lord North Bongaigaon outpost, no?
Yes.
My lord, in the morning also, today morning also, it was informed to the OC concerned, my lord. But till today, at present, my lord, we have not received any information, my lord. I prefer 2 days time, my lord, at least 2 days time, my lord, to take the instruction whether any FIR has been filed against the present petitioner or not.
What is your information says, Mr. Mahmood? Is there any FIR?
The police only sends message that you come, otherwise with 30 lakhs they have demanded. But no FIR is found anywhere. So my lord, my learned friend has made similar prayer in last 2 occasions also.
My lord, I have already said, my lord, we are also communicating, my lord, to the OC
No.
concerned, my lord.
Your contact within OC North Bongaigaon?
My lord.
No, there is one outpost and the
Yes,
the
yes.
Not
Bongaigaon.
Bongaigaon outpost, my lord, Bongaigaon police station.
Under
Under
Bongaigaon police station.
Our officers communicated to the OC Bongaigaon police station also. They also will communicated. Asked them.
No, Bongaigaon is okay, but if the FIR is suppose raised, it will be registered under Bongaigaon. But they file before not Bongaigaon.
Bongaigaon outpost also my lord, through the office of the through
Officer
Bongaigaon
inside
police
Bongaigaon.
also my lord, through officer inside Bongaigaon police also tried to communicate the outpost.
So till date you have not received any information.
No, well, they have not provided any instruction.
Then what will
Well, only because they have not provided any instruction, my lord, interim may be granted to the petitioner and my lord, a last chance may be provided to whether any case pending. Or otherwise, my lord, one last chance may be granted to the my lord, OC Bongaigaon police station to provide their within a period of my lord, 10 days. In case of not providing in case of not providing that report, my lord, your lordship may pass appropriate order for passing.
My lord, from the last communications, it appears that even fourth time also they may not send. So my lord, protection may be given, thereafter let them come. I will cooperate with police.
which I am accounted and it costs for the petition. Also had Bishop and additional PP submitted by Mr. Sharma that stated the report is not received from the North Bongaigaon outpost under the Bongaigaon police station. He submitted that no communication has been made from the office, but the report is not yet sent by North Bongaigaon outpost under Bongaigaon police station as to whether any case has been registered against it. In that context, Mr. Mahmood submitted that on the earlier two occasions also, the same report is submitted by the learned public prosecutor. Accordingly, he submitted that some interim protection may be provided so that he can and cooperate with the investigation if any case is raised. In view of this, let a report be called for, issuing reminder to the North Bongaigaon Police Station under Bongaigaon Police Station as to whether any case has been raised. In the meantime, as an interim, the police of North Bongaigaon outpost is hereby directed not to take any corrosive action against the present petition till receipt of the report. Let the matter be listed when it can be listed.
My lord, 8th of April, my lord. 8th
Or you can list it on 30 or 31.
March.
Oh,
31st of March.
31st. Okay. You got the interim protection is provided. 32.
Made PG Lord. The charge sheeted case, Lordship. In this case, my Lord, I was sworn as an absconder, my Lord. So TCR would be necessary, Lordship. May call for the TCR, my Lord.
Mr. Adal, the council petition. No, do you have anything here? No, we have not received it. It is listed.
But it was listed on Thursday, my Lord.
Oh.
Inadvertently listed today for bail hearing.
For bail
It should
hearing.
have
It
been
should be in
come
motion
motion.
column.
Achha, it should be in motion. Mr. Adal, the learned counsel for the petitioner. And also Mr. B. Sharma, the learned petitioner people, if we can behalf of state response. Let the scan copy of the TCR along with the case.
CD along with
CD be from the concerned court. Registry will do the needful. Yes, when it can. This will come from which place?
Silchar, Lordship.
Silchar. 2nd of April will do. Second.
So second, I am not available, Lordship.
Okay.
6th of April, Lordship. Milord, one clarification was there, Lordship. On Friday, a review application was moved, Milord. My learned friend appeared, Milord. In that case, Milord, what happened? He said that it is for rate of interest, not for rate of interest. But from the date on which the interest was granted. The interest was granted, Milord, from the date of the judgment of this honorable court. Whereas in the whole judgment, it has been reflected that it should be from the date of the filing of the claim petition, Milord. That was there, Lordship. Lordship may not remember. Friday, the matter was there, Lord.
Friday.
Friday.
Matter was there on Friday.
Friday, Lord.
Next
Just
date
a
is-
clarification, nothing, Lord.
Next day?
Oh,
Next year after 3 weeks, Lord. After 3 weeks. Just for clarification, no, nothing for orders, Lord. I am obliged, Lord. Bless.
6th of
The instruction. The instruction was called for. No question.
No.
Particular number? Oh, my lord. No case registered, man.
No.
Against all the accused person, my lord.
How many petitions were there?
That's 4 petitioners.
Abdul Salam.
4 petitioners.
4 petitioners. Abdul Salam, Monirul Islam, Abul Kalam,
yes,
and Monwara Khatun, my lord.
Yes. Mr. A.K. Azad. Counsel for the petition. Distribution of the negation. It is submitted by Mr. Sharma. The report has already been received. From which police station it is?
The Bagbor police station.
Bagbor police station. Borpeta, wherein it is reported that no case has been registered against the court numbers of petitions mentioned in the petition. The WT message be kept with the case record. Next, considering the report, the present petition is hereby disposed of, and the interim granted to the present petitioner is hereby vacated. However, the petitioners will be at liberty to file press application for bail in the event any case is registered against. With the above observation, the dismissed. Okay, you can approach the court in the event
If any case is
raised.
For admission, item number 14.
Yes.
May I please, your lordship? My lord, this is a
D. Gogoi-
criminal.
Just a second. D. Gogoi,
My lord, amicus curiae had been appointed, my lord. We have served copy
the,
also.
The state is also there, but D.
State is
Gogoi-
also
D.
there, my
Gogoi-
lord, because what has happened, my lord, we have given all our efforts, my lord, to serve notice upon the informant, my lord. But those all efforts, even paper publications were also made, my lord. But she has not turned up and contesting, my lord, this petition, my lord. So, my lord, as I am
The
a
last
service,
occasion, most probably the amicus was.
amicus was appointed, my lord, on the by last order, my lord.
Can I cover the protect travel general of court? Notice it.
My lord, we have served a copy upon amicus, my lord, and we have also informed him, and I have just had a talk with him, my lord.
Oh,
Just
sure.
before the matter, my lord. What has happened, my lord, he has left today, but he says that someone on his, my lord, he will appear. D. Gogoi.
D. Gogoi's behalf, anyone is appeal?
Anyone now? No one is here, my lord.
Huh? Mr. Gogoi is coming? Okay.
My
So
lord,
otherwise, state is also party, you can let them come, let him come, you can.
Mal.
No.
Yeah, please, your lordship.
Seventeen, you have filed one affidavit.
One additional affidavit today, lordship.
Huh.
It was a
We
five.
have received the additional affidavit here. Have
Lordship.
you received the copy? What you have brought to an or additional affidavit?
Lordship, she got married and her photograph with her husband, I have annexed, lordship. Annexed that
He
E.
got married. What did your
Respondent number 2.
Huh?
Respondent number 2. Allegation was against me of 69, section 69.
Huh.
We have filed for quashing, lordship. And after 3-4 months, she got married and did not reply to my petition, lordship.
Is anyone is
Is it a joint
appointed here?
petition?
No, not joint petition.
Not joint petition, my lord. Then they will have to come, my lord.
No, where the notice is served on him, on her? I didn't.
Service awaited, my lord, in the last
Awaited,
occasion, my lord. And call for a scanned copy of trial for record and CD, my lord. And record receipt, trial for record receipt, my lord.
May payroll the
But
last.
service is awaited, my lord.
On last occasion, it was observed that no need to send notice, lordship.
No need to
That's
send
why it
notice.
was fixed in admission hearing column,
Acha, so last occasion it was observed?
lordship.
Could observe. Where from you're saying that no notice is to serve?
Lordship, on 22/2026,
Just a 20?
list this matter for admission hearing, lordship. That day orally, this honorable court observed that no need to send notice.
No, where?
22
No,
2000.
I have not seen the order, I have not seen. It will put order to but notice না লাগে আর বলছেন Huh? Order is not there.
Order not
notice is
restricts
not-
punishment, only admit.
Order was not there. Orally,
What was there?
in order, it was written that list this matter for admission hearing, Lordship.
Quote. Where? Study with your-
On 20 February.
My lord, that is the order, my lord. Here is the proof. Only here admission hearing on that is taken today.
Order observation লিখে একটু admission hearing করতে হবে।
My lord, second paragraph also said that, my lord, up to date court records, my lord, that is also all for, my lord.
That is received, Lordship. Up to date.
Up to
cash
date.
record, yes.
No, I'm just asking there where,
Not mentioned, my lord.
Lordship, it is not
reflected in the order.
mentioned.
so what to submit you? You're going to proceed with the case without the service? Or-
My lord, in the last occasion, earlier, my lord, occasion, service report awaited, my lord. But,
Service was awaited.
my lord, service report awaited, my lord. 14/5/2025, my lord, that is.
No, in 5/2/2023, recent order.
My lord. My lord,
Uh,
one thing they may also done, my lord, they may file a joint petition, my lord. If they are quashing, my lord, they have merit,
No.
my lord.
Matter is not settled, Lordship. How can we file joint petition?
Not settled.
Not
How
settled.
they have merit?
They are not married. The girl is married to another person
Oh,
and
that
shifted
is-
to another location, and that's why the notice was not served for
On-
2
on
times,
11
Lordship.
You are on 11/2, you were
Yes.
directed to take instruction.
My lord.
of
Two
a
time-
Public prosecutor.
Yes, Lordship. 2
You were
times
directed to
they
take
were
instruction as
directed to take.
instruction in the said authority in regards to notice service of.
My lord.
So do you have any instructions?
No, not my lord.
If Lordships go through the FIR and charge sheet,
Then,
Lordship,
in that case,
My lord.
you were instructed to take instructions.
My lord.
Because last occasion, most probably it was sent through the officer in charge.
My lord.
So from officer.
My
in
lord, we will
charge,
take instruction, my lord. then. we'll
They
take
have already
instruction.
filed that she got married.
My lord.
Maybe if suppose from your benefit, I'm saying, as Mr. Sharma is submitting, that if she already got married, she may not be in a position to proceed with the case further. She may not be interested to proceed with
But
the
it
case.
is not the condition that, my lord, she married to the another point, my lord.
No,
That's why
no,
the
no.
case is,
That is
not the condition, my lord.
that cannot.
My lord.
here Lordship
You
section
have
69.
cheated. She may marry.
My lord.
What is the harm?
If there was a promise between them and she got married, one case made against her actually, Lordship, not me.
Oh my goodness. What are you saying? What are
False
you
premise
saying?
to
What are you
marry was there,
submitting?
Lordship, not
Think
rape
twice
or
before
anything else,
submitting anything.
Lordship.
Marrying, she got married to another person.
Another girl, that is not the condition precedent for the
That
passing
is
of the.
not a
Prosecution
rape case,
petition.
Lordship.
Rather, you can say that if someone appears for him,
My lord.
for her, and says that she
My
not,
lord,
he is
that
not
may be,
interested,
that
that
may
may
be,
be a case.
that may be the one.
You are Mr.
Yes, Ahmed.
Heard Mr. J.S. Ahmed. Also heard Mr. D. Sharma did an additional PP appearing on the status. The additional affidavit had already been filed, which is received by the integrity district. However, from the office notes, it means that the service is still awaited for the response number. And the learned public prosecutor was hereby asked to take instruction in regards to service of notice. Mr. Sharma, however, submitted that he has no instructions to that effect. In view of this, Mr. Sharma, the additional public prosecutor, is hereby asked to take proper instruction in regards to service of notice to the respondent number two. Respondent number two. List accordingly. When it can be listed, Sharma?
My lord.
You just take instruction.
My lord, my lord.
We have received the case.
My lord.
On 19, Lordship.
19. Just to take inform police also. Just to take exception of the case.
Was third time for instruction.
26 my lord.
Okay, 26.
Obliged.
That I have not reading.
My lord, the Gui is appearing this matter. However, due to some his health issue, he left the court premises. I pray that this matter may on Thursday. Due to some health issue, he has.
My lord. My lord, only thing is that, my lord, I am now around going to retire, my lord. That's the problem. My lord, I am around 59 years. Exact date I have to get out. Because this petition is pending from 2023, my lord. Now, 2 years, 3 years has elapsed. On the day of filing, I was 58 years. So now if this proceeding is pending, there will be some difficulty in my pensionary benefits, my lord. My lord, this is absolutely a bogus application. This lady, my lord, informant, even not turned up for medical examination before the IO, before the honorable magistrate also, my lord, and now in this petition is also, she is not appearing, my lord, turning up. So, my lord, it is a settled law, my lord, that if the informant is not a party, my lord, as evidence, a prosecution witness before the trial, it will be a futile exercise, my lord. So, my lord can consider all these things. Short, my lord. Difficult, my lord. My lord. My lord can fix it on the first week of April also, my lord. 25. Yes, yes, my lord, I can. Okay. My lord, highly obliged. Deeply obliged.
May I please, Lordship? In this case, challenge is made to the order granting extension of time for investigation. What happened, Customs Department on 1/5/2025 arrested the petitioner and two other persons, and 1/5/2025 and two other persons. They were coming from a vehicle from Aizawl side to Silchar side. So, and contraband of commercial quantity was recovered. Thereafter, we filed application before the Honorable High Court also. During the pendency of these bail applications, they filed an application for extension. That was allowed. And our bail application has been rejected on the ground that these were not pleaded, these issues, that granting of an extension was illegal. It was argued, but it was granted by the order dated 27/10/2025.
27/10.
10/2025.
Extension order.
Yes. The implement order According to the code, learned trial code, it was on 175th day.
It was on 175th day.
Now, our basic ground in this that the as per section 36A4 to NDPS Act, extension can be granted, but for I am reading law 36A, section 4.
36A4, yes.
In respect of persons accused of an offense punishable under section 19 or section 24 or section 27A or for offenses involving commercial quantity. The references in subsection 2 of section 167 of the Code of Criminal Procedure 1973, they are up to 90 days, where they occur shall be considered as reference to 180 days. Now, provided that if it is not possible to complete the investigation within the said period of 180 days, the special court may extend the said period up to 1 year on the report of the public prosecutor, indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period of 180 days. So, report of the public prosecutor is required and specific reason why investigation could not be completed that period. Now, in this case, public prosecutor submitted an application, lordship, page 52.
Yes.
Page 52. From page 53, paragraph 1. What he states that on 1/5/2025 at around 12 p.m., the team of customs officers along with 2 independent witnesses intercepted 3 persons, namely, and K. Lalu Tadika of such and such. I am TG Liana. My name is 8th line, TG Liana. Then paragraph 2, that a complete rummaging of the vehicle in the presence of the individual witnesses resulted in recovery of 6 rectangular sized tightly packed packets covered with transparent packets weighing 6 kgs net weight, which is commercial quantity, believed to be of methamphetamine were found. After chemical testing in the presence of the witness and in the presence of the accused, it gave positive test. This is the original complaint only, nothing new. Now, in paragraph 6, he only mentions that the final charge sheet would not be possible to submit it within the stipulated time period of 180 days due to the want of FSL report. As such, the petitioner may be allowed to additional 90 days. It was allowed. And learned what is required as per the dictum of Honorable Supreme Court, that there should be application of mind by the learned special public prosecutor or public prosecutor while filing the application. And secondly, notice has to be issued to the accused person. Now, in this case, in the impugned order, lordship will find it starts from page 57. In page 58, now here also same thing, only recording of his application, and page 58, second paragraph, third paragraph, in view of the above provision. Provision was quoted, 36(4). Thereafter, learned trial court stated, in view of the above provision and considering that the custom preventing forces filed the petition before expiry of the statutory period, through learned special PP, citing valid and reasonable grounds, I find the prayer to be justified. Now, whether there was an application of mind by the special public prosecutor, that has not been addressed. And regarding notice, in last paragraph, page 59, it is mentioned that it is pertinent to mention here that the present petition was filed on 24/10/2025 and the learned counsel appearing for the accused persons received a copy of the petition on the same date. Now, this is our objection, lordship. Even if one bail application, if it was filed and a counsel appears, his bail application is rejected. Does it mean he continuously appearing for him? And there is no trial court record has been called for. My instructions is there is no Okalatnama of Tijiliana engaging any counsel. That's why TCR was called for lordship. And it is a requirement of law that notice has to be issued. In this respect, I beg to rely upon the two decisions, lordship. Although it was in Tata case, the provision is same. First one is Jigar lordship. Jigar and Jimmy reported 2023 6 SSC 484.
Which para you are reading?
Paragraph 23, Madam Lordship, page 12. There is a headline, the effect of the failure of the respondents to produce the appellants before the special court at the time of consideration of the extension application. No, paragraph 23, Lordship, the section 20 of Tata Act has been reproduced. Therefore, the said proviso came up for consideration before this court in the case of Hitendra Vishnu Thakur in paragraph 23. Hitendra Vishnu Thakur also I have submitted lordship, but from here it will be clear. Paragraph 23. We may at this stage also on plain reading of clause BB of subsection 4 of section 20 point out that the legislature has provided for seeking extension of time for completion of investigation on a report of the public prosecutor. The legislature did not purposely leave it to an investigation officer to make an application for seeking extension of time from the court. This provision is in true with the legislative intent to have the investigation completed expeditiously and not allow an accused to be kept in continued detention during unnecessary prolonged investigation at the whims of police. Legislature expects that the investigation must be completed with utmost promptitude, but where it becomes necessary to seek some more time for completion of the investigation, the investigating agency must submit itself to the scrutiny of the public prosecutor in the first instance and satisfy him about the progress of the investigation and furnish reasons for seeking further custody of an accused. A public prosecutor is an important officer of the state government and is appointed by the state under the Code of Criminal Procedure. He is not a part of the investigating agency. He is an independent statutory authority. The public prosecutor is expected to independently apply his mind to the request of the investigating agency before submitting a report to the court for extension of time with a view to enable the investigating agency to complete the investigation. He is not merely a post office or a forwarding agency. A public prosecutor may or may not agree with the reasons given by the investigating officer for seeking extension of time and may find that the investigation had not progressed in the proper manner or that there has been unnecessary, deliberate or avoidable delay in completing the investigation. In that event, he may not submit any report to the court under clause BB to seek extension of time. Thus, for seeking extension of time under clause BB, the public prosecutor, after an independent application of his mind to the request of the investigating agency, is required to make a report to the designated court, indicating therein the progress of the investigation and disclosing justification or for keeping the accused in further custody to enable the investigating agency to complete the investigation. The public prosecutor may attach the request of the investigating officer along with his request or application and on report, but his report as envisaged under clause BB must disclose on the face of it that he has applied his mind and was satisfied with the progress of the investigation and considered grant of further time to complete the investigation necessary. The use of the expression on the report of the public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period as occurring in clause BB in subsection 2 of section 167 as amended by section 24 are important and indicative of the legislative intent not to keep an accused in custody unreasonably and to grant extension only on the report of the public prosecutor. The report of the public prosecutor, therefore, is not merely a formality, but a very vital report because the consequence of its acceptance affects the liberty of an accused and it must, therefore, strictly comply with the requirements as contained in clause BB. The request of an investigating officer for extension of time is no substitute for the report of the public prosecutor. Whether either no report as investigated by clause BB is filed, or the report filed by the public prosecutor is not accepted by the designated court. Since the grant of extension of time under clause BB is neither formality nor automatic, the necessary corollary would be that an accused would be entitled to seek bail, and the court shall release him on bail if he furnishes bail as required by the designated court. It is not merely the question of form in which the request for extension under clause BB is made by one of substance. The contents of the report to be submitted by the public prosecutor after proper application of his mind are designed to assist the designated court to independently decide whether or not extension should be granted in a given case. Keeping in view the consequences of the grant of extension,
The entire para is of this application of mind by
application of mind was
public prosecutor.
public prosecutor. Now, my humble submission in this application, which was filed by the public prosecutor, there is no application of mind independent. That he is satisfied with the investigation so far progress, and why the further custody of the further detention of the accused is required. Now, paragraph 30, loss. The logical and legal consequence of the grant of extension time is the deprivation of the indivisible right available to the accused to claim a default bail. If we accept the argument that the failure of the prosecution to produce the accused before the court and to inform him that the application of extension being considered by the court is a mere procedural irregularity, it will negate the proviso added to subsection 2 of section 20 of 2015 Act, and that may amount to violation of rights conferred by the Article 21 of the Constitution. The reason is the grant of extension of time takes away the right of the accused to get default bail, which is intrinsically connected with the fundamental rights granted under Article 21 of the Constitution. The procedure contemplated by the Article 21 Constitution, which is required to be followed before the liberty of a person is taken away, has to be a fair and reasonable procedure. In fact, procedural safeguards play an important role in protecting the liberty granted by Article 21. The failure to procure the presence of the accused either physically or virtually before the court, and the failure to inform him that the application made by the public prosecutor for the extension of time is being considered is not a mere procedural irregularity. It is a gross illegality that violates the rights of the accused under Article 21. In this case, my humble submission is a notice was given, he was not informed, and it has been considered, only noting that a copy was submitted to some counsels to whom there is no okalattama executed by the present petitioner. Now, this requirement of notice why it was required, it has been dealt by dealt in the case of the Hitendra Vishnu Thakur lordship. Lordship may it takes the Hitendra Vishnu Thakur, page 13. They have considered, the Honorable Supreme Court considered its extension is equivalent to cancellation of bail. That's why notice is required. I am not reading lordship enter paragraph, page 13. It starts with what does. If from paragraph 18, 19, similarly, when a report submitted by the public prosecutor. page 13, Lordship.
Yes, right.
Start with thus, Lordship.
Yes.
Thus, we find that once the period for filing of charge sheet has expired, and either no extension under clause BB has been granted by the designated court, or the period of extension has also expired, the accused person would be entitled to move an application for being admitted to bail under subsection 4 of section 20 TADA, read with section 167 of the code of the code, and the designated court shall release him on bail if the accused seeks to be so released and furnishes the requisite bail. We are not impressed with the argument of the learned counsel for the appellant that on the expiry of the period during which investigation is required to be completed under section 24 TADA, read with section 167 of the code, the court must release the accused on bail on its own motion, even without application from an accused person on his offering to furnish bail. In our opinion, as an accused is required to make an application if he wishes to be released on bail on account of the default of the investigating or prosecuting agency, and once such an application is made, the court should issue a notice to the public prosecutor, who may either show that the prosecution has obtained the order for extension for completion of the investigation from the court under clause BB, or that the challan has been filed in the designated court before the expiry of the prescribed period, or even that the prescribed period has actually not expired and thus resist the grant of bail on the alleged ground of default. The issuance of notice would avoid the possibility of an accused obtaining an order of bail under the default clause by either deliberately or inadvertently concealing certain facts, and would avoid multiplicity of proceedings. It would therefore save the ends of justice if both the sides are heard on a petition for grant of bail on account of the prosecution's default. Similarly, when a report is submitted by the public prosecutor to the designated court for grant of extension under clause BB, its notice should be issued to the accused before granting such an extension, so that an accused may have opportunity to oppose the extension on all legitimate and legal grounds available to him. It is true that neither clause B or nor BB of subsection 4 of section 20 TADA specifically provide for the issuance of such a notice, but in our opinion, the issuance of such a notice must be read into these provisions, both in the interest of the accused and the prosecution, as well as for doing complete justice between the parties. This is a requirement of the principle of natural justice, and the issuance of notice to the accused or the public prosecutor, as the case may be, would accord with the fair play in action, which the courts have always encouraged and even insisted upon. It would also strike a just balance between the interest of the liberty of an accused on one hand and the society at large through the prosecuting agency on the other hand. So, notice is also required. In NTPS also it is not mentioned that a notice is required, but following this principle, notice has to be required. And in our case, Lordship, in the impugned order, only on the last part, it has been mentioned that a copy was furnished to some counsel. Because there are 3 accused persons, so it was assumed that my counsel was also there, and that's why TCR was called for to see whether I have any apalaktoma in this case. So these are the 2 grounds. Actually, this is extension order is illegal. If extension order Lordship finds it is illegal, then I will be I can file an application for default bail, because although they have filed by this time, offense reporters have completed procedure, but I will be I have the right to get this default bail. They have filed it within the extension period, not within the original 180 days period. And in Hitendra Vishnu Thakur, it is also held that paragraph 39, Lordship, that if the extension is illegal, the accused has an indefeasible right to get the bail. Paragraph 39.
Yes.
This must, Lordship may kindly note paragraph 36 also. Of Hitendra Vishnu Thakur. 36 and 39. 39 says that if it is illegal, he has indivisible right, and paragraph 36. This is also on application of mind only.
May I please? Lordship, first I want to place section 36 of NDPS Act. Married law. In respect of persons accused of an offence punishable under section 19 or 24 or section 27A or for offences involving commercial quantity, the reference is in subsection 2 of 167 of the CRPC. Therefore, 90 days where occurred shall be constituted as reference to 180 days. So 90 days has been converted to 180 days. Now, Lordship, provided that it is not possible, if it is not possible to complete the investigation within the said period 180 days, the special court may extend the said period up to 1 year on report of the public prosecutor indicating progress of the investigation and specific reason for detention of the accused beyond the said period of 180 days. Now, Lordship, they challenge the public prosecutor on the report of the investigative officer file an application. Lordship, first I want to place that application, page 52. My learned friend has read out some paragraphs, but probably he has missed out paragraph 4, page 54. He said that no application of mine is there. Paragraph 4, page 54. Married law. That the statutory period of submission of charge sheet falls on 27/10/2025. However, the investigating officer of the instant case has submitted a report on 17/10/2025 that it is unable to complete the investigation within that period of reasons of carrying out further investigation in the instant case and has urged to submit an application for extension of period of investigation in the instant case. The district transport officer reports regarding the ownership and registration of particulars of the seized vehicle is still awaited. The said report is critical for establishing the chain of ownership and liability of the matter and also the other persons involved in the instant case. Such investigation is necessary to the part as such people are always involved in such illegal activity. So paragraph 4 is clear, Lordship, that the public prosecutor applies in independent mind. Lordship, come to page 56. Below the signature of the public prosecutor, copy of the report submitted by IO is annexed hereby. Lordship, the contents of my learned friend that public prosecutor does not apply his independent mind is absolutely incorrect. Now, second objection raised by my learned friend that notice was not served on the accused person. Lordship, at least to see page 52 again. On the right side, Lordship, the copy of the application was served on the counsels who appeared on behalf of the accused person. There are signature of two lawyers. Lordship. Now, Lordship, may please to come to page 57, order passed by the learned trial court extending the period of investigation. Page 57. Married law. Small order. Department case number so and so dated 27/10/25. Today speaks for hearing on petition number so and so filed by the complainant. The custom preventive force Silchar through learned learned SLPP praying for extension of time in respect of statutory period of completion of investigation under provision of NDPS Act. It is stated that in the petition that as per section 36A4 of the NDPS Act 85, the statutory period of completion of investigation in cases involving commercial quantity is 180 days, which is in the present case was going to be expired on 27/10/2025. As such, the accused persons were arrested on 2/5/25. It is further stated that the petition that despite diligent investigation it has not been possible to complete the investigation within said period due to one, non-receipt of DTO's report regarding ownership and registration particulars of the seized vehicle. Two, ongoing investigation regarding subscriber details of CDR of the accused person. It is also stated that the contraband amounts to 6 kgs of methamphetamine tablets, which is clearly constitute commercial quantity under NDPS Act. The present petition was filed on 24/10/2025. That is 175 day of the arrest of the accused and before completion of the statutory period of 180 days. Third, peruse the case record on materials on record. On perusal of the record, it appears that as per procedure, as per seizure list, 6 kgs of methamphetamine tablets were recovered from the possession of the accused persons on 1/5/25 during an operation conducted by a custom officer. The nature and quality of the seized contraband being commercial quantity, the statutory period of investigation is governed by section 36(4) of the NDPS Act, which did as follows. What's if just for I am skipping this. In view of the above provision of the considering that the preventive force, custom preventive force has filed the petition before expiry of the statutory period through the London special PP citing valid and reasonable ground, I find that the prayer to be justified. Accordingly, the petition number so and so filed by the informant custom force through London PPC is allowed. The period of completion of investigation present case is hereby extended for further period of 3 months, and that is 90 days in term of section 36A(4) of NDPS Act 1985. It is pertinent to mention here that the present petition was filed on 24/10/2025, and the learned counsel appearing for the accused persons received the copy of the petition on the same day. However, none appeared on behalf of the accused persons when the matter was taken up for hearing. Accordingly, the petition was taken up for hearing and the present order is passed. Lordship, everything is clear. All the provision of the law has been complied with. And Lordship, furthermore, Lordship, in Supreme Court in case of CBI versus Kapil Vadan, in paragraph 15, 24 and 26, 25. Once, and Lordship, here, the department has filed a charge sheet within the extended period of limitation, and London Trial Court has taken cognizance of that. Lordship, paragraph 15. Paragraph 15. There cannot be any disagreement with the bail setter legal proposition that the right to default bail under section 167(2) CRPC is not only a statutory right, but a right that flows from Article 21 of the Constitution of India. It is an indefeasible right. Nonetheless, it is enforceable only prior to filing of the challan or charge sheet, and does not survive or remain enforceable on the challan being filed if already not available of. Once the challan has been filed, the question of grant of bail has to be considered and decided only with reference to the merit of the case under the provision relating to grant of
bail.
Grant of bail to the accused after filing of the challan. The Constitution bench in Sanjay so and so, while considering the provision of section 24B of Prior Restraint Distributive Act Prevention, probably my learned friend is relying on that provision also. That is section 167(2) CRP has very pertinently held. That's what's it then the judgment has been quoted. Then Lordship may come to page paragraph 24. Lordship may come to subpara 39. Last but one page. Subpara 39, Lordship. The statutory scheme does not lead to conclusion in regard to investigation leading to filing of the final form under subsection 2 of section 173 and further investigation contemplated under subsection 8 thereof. Whereas only when a charge sheet is not filed and investigation is kept pending, benefit of provision appended to subsection 2 of 167 of the CRPC would be available to an offender. Once, however, charge sheet is filed, the said right ceases. Such right does not revive only because a further investigation remain pending within the meaning of subsection 8 of section 173 of the code. Paragraph 25. In view of the above legal position, we have no hesitation to hold that the charge sheet having been filed against the respondent within the prescribed limit and the cognizance have been taken by the special court of the offense alleged committed by them, the respondent could not have claimed the statutory right of default bail under section 167(2) on the ground that investigation qua other accused was pending. Both the special court as well as the high court having committed serious of error of law in disregarding the legal position enunciated and settled by this court. The impugn order deserves to be set aside and accordingly set aside. And in this case, also the accused was given granted default bail. Then in paragraph 26, the respondent accused shall be taken into custody in this case if he released on default bail pursuant to the impugn orders. However, it is clarified that the observation, then let's see, normal observation is there. But see here, all the provision of the law has been complied with by the learned trial court while extending the period of limitation. Notice was served and the public prosecutor in his report applies his mind. I placed before all in paragraph 4 and others. Lordship application of mind is there. The report of the I was also enclosed. And the learned trial court was aware that even though in the section 36A there is no provision of issuance of notice, but learned trial court was conscious about the facts. So in the last paragraph it is mentioned that the notice has been served on the counsel of the petitioner. And Lordship knows when application is moved, no accused is present before the court. Only learned trial court direct that the notice will be served to his counsel. And he was present, he accepted the notice. And Lordship, furthermore, we have filed our objection also. That may be Lordship, paragraph 14, 15.
Your objection.
Objection locus page Lordship may come to page 61.
Yeah.
Let's see paragraph 3, page 61. The petitioner is an accused in a serious offense under section 2129 of NDPS Act involving recovery of 6 kilograms of methamphetamine tablet. Let's see, please to note that the 50 grams is a minimum quantity.
Here it is methamphetamine is 6 kilo.
Yes, Lord, 6 kilo. More than 100 times more than the commercial quantity, which is a commercial quantity punishable with rigorous imprisonment extending up to 20 years along with fine. Then paragraph 5, that before expiry of the statutory period of 180 days prescribed under section 36A of the NDPS Act, an application for extension of time was filed by the public prosecutor under section 36A of the NDPS Act, clearly indicating the progress of investigation as well as a specific reason necessitating further detention of the accused person. Paragraph 6, the special judge Kachar Silchar, after considering the said application and upon due application of judicial mind, was pleased to pass order dated 27/10/25, extending the period of completion of the investigation by further period of 90 days in strict compliance of section 36A4 of the Act. Number 7, the advocate Sri Devamalai Chakravarti appeared for the accused had applied for bail of the accused on 16/6/2025, and learned advocate Sri Devamalai Chakravarti was duly served with the departmental petitions for extension of time on 24/10/2025 under due acknowledgement. Therefore, the contention that no notice was received by the accused, as point was in paragraph 5 of the petition of the accused TG Liana, is not based on facts. Proximal learned friend time and again submitted that he does not sign any wakalatnama by the accused person. Proximal please to see whether he was authorized to file a bail application on behalf of the accused. And at that time, Lord, if he was moving the bail application, notice was served on him. He could have refused also, Lord. But he was the advocate of the accused person for moving bail. That is sufficient, more than sufficient, Lord. Then paragraph 9. The contention of the petitioner that the impugn order is illegal due to non-issuance of notice, which is not the fact here, is also untenable in law, as section 36(4) of the NDPS Act does not mandate issuance of prior notice to the accused as a condition precedent for granting extension. The statutory requirement is only that the extension must be based on report of the public prosecutor and satisfaction of the court. However, Lordship, notice was served on the accused person. The learned trial court has also mentioned. Then paragraph 10, the Honorable Supreme Court in case of Hitendra Vishnu Thakur, which my learned friend is relied, and Sanjay Dutt reported in 94/5 SCC has categorically held that the extension of time for investigation can be granted before expiry of statutory period, and that right to default bail is not absolute. Then paragraph 14, Lordship. Since the extension of time was sought before expiry of 180 days and was granted by the competent court, no infeasible right of the default of bail in favor of the petitioner, this legal position has been reaffirmed by the Honorable Supreme Court in case of R. Ravindran versus so and so. And Lordship, I place the judgment. Once charge sheet has been filed, he has seizes the right to default. Here, Lordship, rightly, the learned trial court has granted extension of time for 90 days. And within 90 days, Lordship, the complaint was filed. And Lordship, moreover, his bail application on merit was considered by this honorable court and by rejected. That order has been placed by my learned friend also. It is page 46. Lordship, may I come to page 50. Paragraph 11. In view of the aforesaid submission which has been made in the instant case, the accused applicant about passing of the order dated 27/10/25 is not tenable at this stage in the instant application. Therefore, this court refrains from getting into the aspect of the legality or illegality of the order dated 27/20/25 passed by the learned district and session judge, special judge Kachar Silchar. Paragraph 12. Take into account of the facts that the quantity of the seized contraband is 6 kg, which falls category of commercial quantity. The regards of section 37 shall be applicable in the instant case. After considering the whole aspect in its entirety, this court is of the considered opinion that at this stage the ruling of the accused person should not be granted.
It was filed after the extension.
Yes, Lord. It was filed after the extension. It was decided on 2011/2025. So in my humble submission, Lordship, the extension was rightly granted after considering and following the due process of law. And Lordship, furthermore, within the extended period, the department has filed its charge sheet and landed trial court has taken cognizance of the same. So the default bail is granted to the petitioner, he has ceased to his right of default bail. And this is clearly held by the Honorable Supreme Court in case of CBI versus Kapil Varma. In view of the same, Lordship, the revision petition is liable to be dismissed.
May I please, Lordship? Regarding notice, Lordship, serving up a copy to a counsel who appeared once for moving a bail application does not amount to, because the bail application was disposed of.
But you have received.
Huh?
But you have received the copy.
No, accused has not received. Now, number first, he has received. Counsel received. That counsel has received.
Refused the bail, receiving the bail application stating that I'm only engaged for moving the
He should
bail
not have.
application.
He should not have.
But he had received only.
But my humble submission
Go
is
by the statute also, there is that provision of precondition to
no.
notice to the, yes, obviously for the ensure justice for things and all, for the natural.
Yes,
justice, that is
if
there.
I
That may be
appear,
there, but it's not the.
if I appear in a bail application, Lordship, if I appear in a bail application, it is allowed, granted, bail is granted. Then the prosecution comes for extension, this cancellation of bail application. Can they serve this copy upon me, or it should go to the person concerned? The same principle has to be applied in here also, because it is extension of the period. Secondly, I have already submitted that record will speak, Lordship, whether this person has filed an okolotnama or not. If he has signed any okolotnama in favor of this person, this advocate counsel, then my submission regarding notice may not be considered. But if there is no okolotnama, he should be engaged by a valid okolotnama. Otherwise, he cannot. And regarding this application of mine, Lordship, it has been Jigar case, it has been time and again says that there should be satisfaction. That is, the report must disclose on the face of it that he has applied his mind and was satisfied with the progress of the investigation and considered grant of further time to complete the investigation necessary. My humble submission, this is also absent in the application of the this application filed by the learned public prosecutor, and that aspect has not been noticed by the learned trial court.
We'll deliver the order on 20th.
No, sir. Much obliged.
May I please, your Lordship, there is a connected matter which was listed before court number 8 today, and the same was fixed on 6th of April, tagged with this matter.
Tag with it.
Yes.
But earlier the order was not there, tagging this matter.
Earlier, Lordship, it was prayed for, but the same has not been tagged with this.
It is a connected matter.
Connected matter, yes.
Of the same order with two paired vehicles. So it was connected lot. So I am for response number 3 here and response number 2 in the other. In the other case, not it was in court number 8 and this date was 6th of April and connected with this character. This will be listed on 6-4.
What is the number of the other case? The other
Other case is
94.
94.
94.
26?
Yes.
You are Mr.
Arbora.
Hard Mr. Harper. Deputation. Mr. You are?
Appearing on behalf of CBI Lordship and Kumar.
Your good name?
P. Majumdar.
P. Muzum. Appearing on behalf of the Standing Council CBI.
Yes.
I'm appearing on behalf of M. Kumar. M. Kumari, standing on CBI. Post of it is submitted by council for the council application that the one collected matter is also pending before a court and bench, which is numbered as criminal division petition number 94 of same as the fixed on 6 court. In view of this, let the present different petition be listed with criminal division petition number 94 of 6 court.
The last one, you have directed loud.
Written objection.
Objection. We may not be allowed. For example, NPDI.
Part considering the submission date that the respondent number 3 as well as the CBI is hereby he is at liberty to file their written objection if any on or before the next.
Pleasure. May it please the Lord. This is a regular appeal against conviction under section 304B IPC.
304
B.
B
Dowry
IPC.
death. There is a connected.
Here appeal was earlier admitted or not yet?
Not yet admitted,
Not yet.
madam. Record also not called for, madam.
Record also not.
Not called for.
It was initially it was before the division.
My lord.
Oh. Now you have one IA also.
IA for connected for
Uh,
paid.
What was the term of conviction?
10 years, madam. 10 years, madam.
We have received the case record.
No,
No.
Today
madam.
first
Today the first. Part Mr. Asteroid.
MH plus.
Petition. Mr. Sharma, the learned petition. Appearing on behalf. It's the- it's- Section 415, Section 2 of PNSS against the imprint judgment and order dated 19/01/2026. First in sessions case number 69 of it by learned additional session judge FTC Churchill, convicting the accused appellant section 304B PC and sentenced to undergo for 10 years along with a fine of rupees 20,000 with deposit. Appeal being the statutory is admitted for hearing. Call for the DCR. Registrable to the need to is the matter needed on receipt of. Here, is there any? I mean, respondent number 2 is also here. No. Only state is the party.
No, party.
Oh no, informant is the party here.
My lord, party.
Then issue notice.
Notice.
Issue notice to the informant respondent to the speak post and takes case for the respondent number. Otherwise, it's okay. Even if in absence also it can be 304B only.
Fine.
And we'll fix the matter accordingly. Your eye will be maybe taken up on receipt of the case record. In I also you can take steps for issuing this. In I also. If you want to press the I also you can take steps. That's what.
Then separate order may be passed in the IIP.
Okay. I no formal notice is required to be. However, notice may be the informant phone number.
Take may be fixed after 4 weeks. Matter.
After 4 weeks, in receipt of immediately on receipt of DLC will fix.
Sometimes
immediately on receipt of DLC. Yes, sometimes.
Sometimes what happen, my lord, they send requisition, but the LCA does not come. So matter again come, then again the court directs that you again spend the first requisition. So
depends what to do. On
so if
immediately on
LCA,
receipt of DLC.
if LCA does not come, then the case will not be listed here.
After 4 weeks or 6.
After 4 weeks. We are not fixing anything.
Okay, Lord, after 4 weeks. Oblige, Lord.
Lordship, may kindly pay last order, my lord. In earlier 2 occasions, they are not present, my lord. Non-appears, my lord.
Oh.
As per office note, my lord, 12/3/2026, my lord, they have not also taken steps.
But whether it is appeal was admitted. If it is admitted.
It's a matter of 2017.
Then it is admitted. I think.
My
Yes, it is admitted. If it is admitted, then you have to dispose of on merit.
My
That is the issue. Okay, none appears for the list amendment. 4 weeks. As
My-
admitted.
My lord, in this case, as per office note dated 11 March 2026, addressee is not available on the addressee left the place. Now, my lord, just now, within half an hour, I got information that addressee is residing in Tinsukia, my lord.
Then
So-
they will take
Got the proper address there?
Yes, he's
Present
residing
address-
permanently at
present
Tinsukia. So I may be allowed to take steps upon the respondent number 2 with the present address, with a new address. Through OC, Tinsukia, and the Justice Service, my lord. These two
So
will be.
the notice has to go because it is a case against acquittal, na?
Yes,
Tinsukia, na?
yes, Tinsukia, my lord. Justice Service, I will take.
That's the service, how it is in the
Criminal case.
Fine.
Address to
officer in charge of.
officer in charge.
Yes, the officer in charge of Tinsukia Police Station.
Or Mr. Lieutenant. Participation. This indeed is still awaited. It is submitted by Mr. Looked at that if you could collect the present address of the respondent number 2. I think which he
In
may
7
be
days,
allowed
my
to
lord.
take. He may be allowed to take rest. Prayer allowed. It may be issued to the respondent to be the present proper address. That apart, the petitioner is also hereby applicant is also hereby asked to take steps through the OC of the concerned police station. That is Tinsukia.
Tinsukia, my lord.
Tinsukia suburb. List. We listed after 3 weeks.
Yes.
We cannot fix it
Ma'am.
here.
Obliged.
May it please your lordship. Lordship, kindly peruse the last order of this court, lordship.
My lord, here service report received, my lord. Notice served, my lord.
Served.
Since POCSO lordship, amicus curiae has to be appointed.
No one is appearing.
My lord.
$35 is criminal appeal 248 of 2023
Yes.
and 36 is 60/2023. Out of same judgment,
My lord.
Sit,
Same
sit.
judgment, my lord. Here.
you are appealing for. In item 36, you are appealing.
Yes.
Yes, want to say something? 36 is also same.
My lord, same, my lord. There is no IA in 36, my lord. Already I have disposed of.
They are on bail.
They are on. Learned additional statement on is submitted to Mr. Sharma that the service notice has already been served to the respondent number to save the responsibility. But it just no is represent in view of this, let a amicus be appointed to represent the respondent. Cape Town is hereby appointed as an amicus to represent the respondent number two. The registry will do the in informing the amicus, learned amicus list. Reporting.
Since Lordship, this petitioner in jail, Lordship, for 3 years, 4 months, Lordship, sentences for 10 years, Lordship.
Here,
31st of this month. This month.
here we will have to file our objection also. If they are placed for IMR, they are 10 years conviction.
Within 31st, will you be able to? No. 31st of March or 1st of March, second?
Second of.
2nd of April.
Second, Lordship, may not be second, after 6 March or 6 April. Can it be on 6 April?
6th April. No.
Hello.
Same order taken. I would say.
May I please, Your Lordship.
7, what is it?
Last 24/9/2025, it was directed to the prosecution side to take instruction whether it was been served or not. As of the office note, that they, neither the answer report has come or the service report has been come, but I have collected the status rating report by myself. Lordship may be also verified through the registry that it was been duly served, delivered to the respondent number 2. And on 24/9/2025, it was directed to the prosecution side to take the instruction.
Yes, do you have any?
No, not today, not
24/10 also.
24/10.
Also, it was been directed.
Due to the non-paucity of time, that is not that.
There was no such direction. Direction I have seen here.
Earlier order.
Yes, on 24/9 there was.
24.
You are Mr.
M. Rabbani.
Mr. M. Rupani, the learned P. Sharma, from the office of the service is still awaited the response. And it is submitted by Mr. Sharma that he could get the instruction in regards to service of notice and response. However, Mr. Rupani, the learned counsel, that he received the track consignment report where it is seen that the notice has already been delivered. Yes. Let the copy be kept with the here and the registry is thereby directed to make a verification that this the matter accordingly. You want any fixed date or 3 weeks will do?
May fix it on first week of the April, if subject to the convenient of.
Second.
Can it take?
2nd April.
2nd April. Oh, hello.
2nd April. 30.
May it please your lordship. Lordship, as per the last order dated 27 February, steps for service of notice was to be taken on respondent 2, which we have taken, but perhaps that might not have been reflected in the record.
No.
Lordship, may kindly perish 12/3.
No,
Office note,
but you have already taken.
Yes, your lordship, we have taken on 13th March.
13th of March.
Yes, your lordship. Through
But your notice of maybe
13th March.
Yes.
Notice of 12th March,
only
maybe. Your MSc Kalita?
Yes.
MSc Kalita. It is submitted by MS Karita that they have already taken step for the respondent number 2 on in 3/2026, and for which the service note does not reflect this steps taken by the present applicant. In view of this, let the service be awaited in next date of this. It is then also through that procedure you have
Yes, we've taken it through the office of TP as per practice selection.
yes. So, but
Mine.
your stamp is also not there.
Not here, perhaps it
It is not.
not received, my lord.
3 weeks will do, or you want any fixed date?
Yes, Your Lordship, fixed it.
Twenty 20.
Oblige, Your Lordship.
Lordship, kindly produce office note, my lord, 12/3, my lord.
It is taken on 12 treats.
My lord.
And appears call for the. Oh, you are here the complainant or what?
No, my lord, here.
Oh no, I thought that in the last occasion also there is no mention about their presence. Oh, anyway,
Office
yes.
note, my lord, office note.
Yes, okay. No, none appears to
12
call for the petition. Mr. Bisham from the office note dated 12/3/2026. The trivial steps has already been taken. The respondent number 2. Let this service be awaited in the executive testing. Please the matter after 3 weeks as will be.
Yes.
Yes, 40/41 of the
Lordship. 40/41 Lordship, in item number 41, we have received a copy of Lordship in last week, and LCR was also not called for Lordship, that is necessary. And in item 40 Lordship, this matter has been stayed, the proceeding of this domestic violence has been stayed Lordship. And this case may be fixed for, alia was fixed for Lordship hearing. Now, since these two matters have been taken together, so now it is again common orders follow. If Lordship, both these cases may be fixed for hearing Lordship, and also call for the case record of item number 41.
No, just tell us in item number 40, what is the position? Item 42.
Item 40 Lordship, yeah, we have challenged the Lordship proceeding of DV proceeding.
No, it's okay.
Yes.
Item 40, you have a one interim.
The proceeding has been stayed Lordship.
Proceeding has been stayed.
Stayed. And now they have filed an IA.
Item 40.
Yes.
File an IA.
You have filed an IA in item number 40. Why?
40 for vacating the stay.
For
Because
vacating
this
the
is a DV proceeding and the stay is going on since 4 years.
Oh. Achha.
This is gross
So
injustice.
otherwise, though it is in order column, both the matters can be listed for hearing.
Yes.
Both can be listed for hearing, but the question is this, Your Lordship, that is 41. The scan copies may be called for, but this 40 and 41 are different. 41 is under 125 proceedings.
Oh,
under 121 proceedings, final judgment has been passed. It was an ex parte judgment. When the execution was going on, the husband appeared, and then that ex parte judgment got vacated, and we have challenged that because we have taken the court honorable.
What is the stage of the case at 125 now? That is
125 final judgment has been passed, and
no, regarding the execution is stayed or
execution has stayed. That is, the execution was going on. During the stage of execution, several steps were taken as per the direction of the learned trial court. The opposite party was not turning up.
And ultimately, through the embassy, we got it served. And under the fear, he turned up and then he filed a petition before the learned family court, paying for vacating the ex parte proceedings.
that has already been allowed or still
It
pending?
has been allowed. That petition has been charged in 125. And
Wait,
the one is,
I mean, do it record a patch. 41, we are not getting the record. I think.
that is a scanned copies can be called. But 40, Your Honor, that is this is gross injustice. This proceeding should wind up within 60 days. It is admitted. Maintenance factor is there. There is no roof provided. And it is an admitted fact. The
So what to
respondent
do?
has admitted that
You
I'm
want
not
to-
paying.
You want to go for hearing of 41? 40?
40. That is regarding 40. I want just the stay may be vacated. Otherwise, the hearing,
Heard. Otherwise, how can?
that is it.
And
Leave to the
Lordship,
business of
allow me to
honorable
1
court.
minute, Lordship. Lordship,
Yeah,
allow
that is-
me.
Let me finish off.
Okay,
That's,
okay. Finish it.
No, sorry, we are not going to hear the matter. Just I'm asking, and 40, now the position of 40 is that
The
you
position
filed
of
one
40 is-
petition for vacating the order,
The
that is
position-
there only. Otherwise, it may be disposed of.
Otherwise, it
IA can be disposed of, or as a whole, the
As a
entire
whole, it
petition
can be disposed of.
the whole it can be disposed of, or IA can be disposed of.
Okay.
That is, I'm
Then
willing for
in
both.
that case, we can fix it on hearing column, or what do you suggest?
And leave it to the honorable court. That is where that is. If IA is there, it can be put for the hearing. That is admission. That is if the main
Then
case.
we do one thing. In that case, we'll do what we'll do. We'll let the matter be listed in admission column, because sometimes it happens, I'm just frankly speaking, hearing may not touch also, because there are many matters.
I understand. I understand.
So in that case, if it is fixed on admission column, it may be hard. In case of item number 40, I'm saying. Item number 40, there IA is there and other matter is also there. Both the matters may be hard. Now, it can be listed in admission column. But what about the 41? We have not received the case record till
In
then.
the meanwhile, scan copies can be called.
In 41.
41.
So it will be still, you want to be tagged together, or?
No, Your Honor, that is regarding tagging will be gross injustice regarding the victim. Regarding 41 is separate, and that is for 40. He has come to the court.
Already there is an order, Lordship. Already there is an order, Lordship. If
For tagging?
yes,
I have, this
Yes,
is the
Lordship.
wife has spread for tagging, not
No.
he. It
but
is the
otherwise
wife.
there is an order of this honorable court to tag this board this case
So
together.
if it is already there.
Yes,
so
if
then-
I'll understand come for vacating that order, not to tag what this case is,
Your
then
Lordship,
I will.
I'm without a roof.
Yes,
And it has
absolutely is misleading, Lordship.
No.
He is
Your-
misleading,
No,
Lordship.
no, let me.
Had my
no.
client been here in India,
No,
I would
no.
have filed a perjury proceeding against this petitioner.
How
She
you
has-
file it? File
She
it.
should be grateful
No,
to my
no, no.
client, Lordship, because yes, what is
No,
yes,
Your Lordship, it's a misleading the court. This,
No, it's okay. Now the
No, no,
question
I am
is
giving
that
a
I'm not
document.
going to hear
She
the
is
question
receiving maintenance from me, Lordship, but in this
What-
petition
what
will
order?
pass down. That is why I am saying she should be grateful, despite there is no order of this honorable court. I am paying maintenance.
willingly.
Yes. So what is my fault? I am paying willingly. What is my fault?
Willingly.
Willingly,
It's not
I am
the court's
paying.
order. He's not allowing the court to pass an order.
Lordship, I am paying willingly. What is my?
He is paying willingly.
Yes. He should be grateful to me, Lordship.
Your Lordship, when he's paying since 24. And
Not
I-
24. That is also misleading, Lordship. I am giving us the bank statement, Lord. She has been receiving maintenance, Lordship, from 7th of December 23. All bank statement I have given. Now, Lordship, in the first paragraph of this petition, she has given a statement. Had my client been here in India, I would have filed perjury proceeding against this person. Because she has been
Valid.
receiving maintenance, but she is denying. And my client has been also aware about that. Because in family court, he is appearing. In every family court, every day we are submitting the bank statement and affidavit as a petition that my client is residing in Oman. So we are paying. Now, despite he is aware of this fact, he has filed this petition. If he is lucky that my client is not in India. Had he been in India, let's say I would have filed perjury proceeding against this person.
Your Lordship, page number 7 of his petition.
No, it's
That
okay.
is different issue.
No, Your Lordship.
My petition,
No,
then
no,
I will be heard first because I am the petitioner. I am the petitioner. Let me heard me first.
No, we are not going to hear
Then
the
it's
case.
fine,
The
Lordship.
question is that we are listing in both 40 in admission column. What about 41? I'm asking.
But 41 is that, Lordship. What is their intention? My
No, they
my
are
client.
paying for vacating
That is
the
why I am
case
saying,
column.
Lordship. My client is residing in Oman. She didn't receive any summon. Subsequently, in 19, he received summon. He came. Let me submit 1 minute. Then he came to India, submitted an application. Since he was in Oman, did not receive any notice, so that may be vacated, and we are also ready to pay maintenance. After 2 years, Lordship, that Honorable Trial Court has recalled the first order and it was fixed for evidence. Now, that order has been challenged. What is your intention? 125 proceeding only to pay maintenance, not to punish my client. If they are, interested to, yes, if he is interested to receive
Why you are
maintenance,
challenging the order?
why he is challenging this order?
I'm coming to the point.
If the case
Yes,
is
only for maintenance, why he has
is
challenged the
for
order?
inter-party, then it will benefit you only.
Lordship,
For your
But their
benefit.
intention is different.
I'm not being allowed to.
My client to pull back
What
from
is-
Oman,
No, no, no.
he had to punish. That is their intention.
Your Lordship.
One after another, they are filing petition, and in family court also, they are lordship submitting
Your
that.
Lordship,
High court has, there is a petition pending High Court.
Your Lordship, let me hear.
All are misleading statement.
One
All
minute,
are
I'll
misleading
give.
lordship.
1 minute.
Not going hearing the case. That's
No, no, Your
what is the status of
In 240, I'm saying, in 240, what has happened? That is under the DV Act, the provision of appeal is there.
Why should I
That-
go forever?
no,
Whole case is not
no,
maintainable. Whole
let-
case is not maintainable. We have challenged
See,
there is maintainability.
Let me finish off.
Lordship, we have
I'm
challenged
not
there is
being allowed to
maintainability.
speak. I'm not being allowed to submit. That is my submission is 240 is a petition which has been filed under section 12 of the DV Act. Now, any order which has been passed, DV Act is complete in itself.
under
When-
29 appeal.
Under 29
Appeal is there. Why
let-
should I go to appeal?
wait.
Where the case is not maintainable?
Now,
We have
let
challenged the
me finish
maintainability.
up.
After 6 years, he has filed
Your-
proceeding lordship.
Your Lordship, let me finish. Let me finish.
You finish properly in right way, not in wrong way.
You don't have patience?
Then
Why you are addressing me? Address the court.
you
Your Lordship,
you
that
address
is-
properly.
Are-
What I'm saying.
are-
Everyone knows there is a appellate
are-
provision in GPA proceeding.
Your
You
Lordship,
doesn't know.
Your Lordship, there is a
Don't have time in.
Your Lordship, there is a provision in
Everybody knows
provision-
it.
again. Your Lordship, there is a provision under the 29. What has happened in this act, this case is after filing, the respondent he has appeared. He has filed his written statements. In written statements, there is no stand he has taken. That is the court is not having to do.
Not going to hear the case.
No, anyway, I'm giving a flash.
The status of the case. That's all. So, solicitude 48 number case to hear go to a admission column of this group. And 41 also admission column of this group 41. Call for this scan copy of this. Registry will do in it, both the matters be listed in admission. We're listing both the matters in admission column.
Lordship.
And we're calling for the TCR, scan copy of the TCR in item number 41.
40 lordship, there is interim order lordship that may be continued.
In which case?
In 40, item 40.
Item 40, interim be continued. And admission. 30. 30 will do. 30 March of this month. Both the matters are listing up.
Lodge. Oblige.
My lord, for that, my lord, item 35, my lord,
Hmm.
and that is Saddam Hussein, my lord. I have verified the record, my lord. It seems that, my lord, we have already filed our objection. My lord, objection
Is already recorded.
my lord, already there, my lord.
In item 35.
35, my lord. I paid for filing objection, my lord, but
Ah,
on the record it reveals that, my lord, already filed.
35 double listening.
Objection already filed.
Yeah, 164 আছে তো? তাহলে regular record. And on getting this submission made by Mr. Sharma, it seems that the objection has already been filed, which is available in the record. হয়নি।
I'm against the point for that.
Then it's okay. 6-4 will hear to me.
My lord.
And if you estimate exchange after 4 weeks, then it will.
Hey, please, my lords. On the last occasion, the court had directed that the track consignment report be placed. It has, my lord, reflected that the respondent who has been served on
13/3/26.
yes, it was delivered on 21/1/26, my lords. Therefore, it may be deemed to have been served upon the private respondent.
13-3.
Yes. That is perhaps the office note dated, my lord. And as per the track consignment report, my lord will find it in the second file. It has been reflected as delivered on 21/1/2026.
Second file, my lord. Track mark is there.
The second file. It has been flag marked.
The basis of the track consignment report 13-3 office notice given.
Yes, delivered on 21/1/26. And regarding my lord, the earlier two case diaries were also called for. Both case diaries I have received.
Yes, there
This would be as 959 and 960 of the
is a case of what kind of
criminal petition, my lord. They have filed this criminal petition for crossing of the app.
no nature of
Nature of, my lord, actually what happened, my lord, earlier the present FIR, my lord, she has lodged an FIR against the present petitioner while they went to the police station regarding to inquire about a case, my lord. At that point of time, some videography was done by the present petitioner, my lord. At that point of time, she abused and, my lord, trying to use slang words only. That is, my lord, use slang words against those petitioners. That is
May I
anyway,
clarify?
the notice has already been served now.
Yes.
notice served.
Yes. You take up
And we
admission.
have case diary we have also received.
Yes, case diary report.
Third, Mr. A. Burva, Dilanet from the petition. Mr. B. Bot, Dilanet, PP, April. It is submitted by Mr. Burva as well as this one. Dated 13/3/2026. This in service is already completed on record number 2. And the as for the back assignment report also, the notice was delivered to the respondent on 21/01/6. The expert Mr. Bot submitted this diary has already been received. In view of this, let the matter be listed for admission hearing. For the deadline. 31/3, which
Yes, 31.
Always listing it by admission.
yes, admission.
Also obliged.
45A Assam is there, na?
Yes, WPC criminal. But however, my lord, on that day I also appeared regarding the case has been filed. Regarding the allegation is that, my lord, although without registering any case, the mobile phone of the petitioner was, my lord, kept in the police station, and, my lord, that was also not handed over to the petitioner. My lord. Regarding that respect, my lord, I have received a report.
Basically, this WP criminal was filed stating that the mobile handset was seized without
And,
registering any case.
Yes, without registering any case, and that was also not handed over to the, my lord, petitioner. That
So
is-
now, after receiving the report, what?
Your lordship, because government advocate also, my lord,
Not there.
earlier, Jay Goswami
Okay,
appeared.
then we pass the
I will
second
have to,
order
but
now.
otherwise, my lord, because on that day I was also there, so I, my lord, tried to
Copy
got
the
this report. That may be kept as a part of the record.
You are MS,
It's Burra.
Hard MS H. Purva, the learned counsel for the petition, also heard Mr.
Mohammed
P. Water, the learned petition, PP, the comments advocate is Mr. Waterfall submitted at the earlier opportunity was present. He had already received report from officer in charge all women police station, wherein it is reported that initially a mobile handset was seized from the person on the petition on suspicion of possession of some illegal data in respect to a complaint case. But subsequently, finding the materials, case has already been registered under all women police station case number on 2502. Let the report be kept as a part of the record. Matter may be listed. It will be listed on 30.
Yes, 30, my lord.
Today you two are only here.
Yes, my lord.
Others are also busy.
Yes. Konkon, my lord, he is now father, my lord, of a baby, my lord.
What's that?
Yes, sir.